We'll start. The first order of business deals with the State Corporation Commission.
Mr. Chairman, I think we need to take roll.
Okay. Go ahead.
Mr. Chair, you have a quorum.
Thank you. The first order of business will be with the State Corporation Commission. You remember last year we interviewed Jamal Hudson, and all we need to do now by voice vote is to, and we found him qualified last year, is to do it again. So I need a motion.
So moved.
All right, all those in favor of finding Commissioner Hudson qualified, say aye. It's a voice vote. All right, the second order of business on the State Corporation Commission involves Angela Navarro. A subcommittee had interviewed her last year. She did very well. She is standing by because she wants to make a statement and then take any questions from the committee. Ms. Navarro, are you near? Are you ready to go?
Yes, Mr. Chairman, I am.
Okay, go ahead.
Thanks, Mr. Chairman, members of the committee, for the opportunity to speak with you today as you consider the election of a successor to fill the unexpired term of former State Corporation Commissioner Mark Christie. I appreciate your consideration of me to fulfill that unexpired term. I do have just a few brief remarks and welcome the opportunity to answer your questions today. I've served the Commonwealth in a variety of roles over the last decade, and I truly believe that there is no higher honor than public service. I also understand the tremendous responsibility of a commissioner on the State Corporation Commission. As we all know, the General Assembly passes the laws that prescribe the scope of the commission's jurisdiction and the various regulatory, adjudicatory, and administrative functions of the commission. And my goal is to work to ensure that I uphold the will of this body and execute the powers and duties of the commissioner in a way that's both transparent and fair. I do bring a degree of experience to this position. I have worked with the State Corporation Commission in a number of roles over the years. I have participated in formal proceedings before the commission as an attorney. I have served as Deputy Secretary of Natural Resources and Deputy Secretary of Commerce and Trade, where I've worked on energy issues, regulatory matters, financial services issues, insurance matters, and a number of other issues that fall within the commission's jurisdiction. The scope of the commission, as we all know, is extensive, and I have certainly started the task of learning more every day about the many duties and functions of the various divisions within the commission. And if elected by the General Assembly, I look forward to continuing this work. I know it's an especially important time, especially as we are working to recover from the economic impacts of this pandemic. So thank you, Mr. Chairman. Thank you, members of the committee, again, for the opportunity to speak with you this afternoon, and I welcome the opportunity to answer any questions that you may have.
All right, are there any questions of Ms. Navarro? Senator Norman.
Thank you very much for your introductory comments. I'm interested in what your experience has been in banking regulation.
Thank you, Senator Norman. I do appreciate that question. So I have worked in my role as Deputy Secretary of Commerce and Trade on a number of issues that impact the banking sector. Those issues, I think, have come front and center over the last year, especially as we've been dealing with issues around rollout of the Paycheck Protection Program. Our financial institutions, of course, have been offering that program to a number of small businesses around the Commonwealth. And as Deputy Secretary of Commerce and Trade, I worked to stand up a program called Rebuild Virginia that provided some complementary financial assistance to a number of small businesses. So we worked with the banking sector in the development and implementation of that program, so they sort of understood how those two programs interacted with each other. I have been having some very significant conversations with Commissioner Face about the many new regulatory programs that are within the Bureau of Financial Institutions. A number of those programs address short-term loans, and so I'm certainly getting involved in the process of those regulatory programs as well.
Mr. Chairman, thank you for that response. What has been your experience in regulations pertaining to insurance, not what your parenthetical experiences are, but as far as regulation of insurance industry?
Thank you, Senator Norment, for that question. Again, as it relates to the insurance sector, most of my experience has really revolved around the work that I've done as Deputy Secretary of Commerce and Trade. Certainly understanding the various insurance programs that the State Corporation Commission oversees, whether that relates to health insurance marketplaces, insurance around long-term care facilities, workers' compensation insurance, motor vehicle insurance, the various sectors of insurance that the Bureau of Insurance oversees, and sort of understanding what those regulatory programs are. As we all know, the General Assembly prescribes the scope of those programs, and so there certainly have been changes made over the last couple of years. One of the most significant of which that will come before the Commission's jurisdiction is the establishment of the State Health Benefit Exchange. And the Commission has recently hired Victoria Savoy, who used to be with the Commission. She is going to be standing up that program. So we'll certainly have significant new responsibility associated with ensuring that that program runs effectively. And then, of course, there are modifications around understanding the liquidity of the insurance market, especially as we're thinking about overcoming some of the financial impacts associated with the pandemic.
One last question, Mr. Chairman. A question that individually is most important to me. As I read your bio, it appears to me that you have had a tilted bias towards being on the vanguard of promoting environmentalism issues over business issues. What assurance can you give me that you're going to take a balanced approach if you are selected to the State Corporation Commission?
Thank you, Senator Norment. So commissioners on the State Corporation Commission are governed by the canons of judicial conduct. And the canons of judicial conduct prescribe that we not prejudge issues that come before us, but that we adjudicate issues on a case-by-case basis, depending on the merits of the case, and of course, interpreting the laws that are set forth by the General Assembly. And I intend to uphold those canons as faithfully as every commissioner that has sat before me. So that is what I intend to do as my role as a commissioner.
Mr. Chairman, a comment. I am certainly not as intimately familiar as you are with what the regulations are of commissioners, but I'm pretty conversant with it. My concern is, do you bring a predisposition to that commission, which would not be precluded by any rules or regulations, that is going to consistently favor environmental issues over reasonable business and economic development opportunities by regulated industries?
Thank you, Senator Norment. Was that a question? I'm so sorry. I thought you said that was a comment.
He asked a question.
Okay. Yes, absolutely. So I have served in both the Natural Resources Secretariat and the Commerce and Trade Secretariat. And I understand the need to balance the issues associated with environmental protection and environmental stewardship with the economy and issues that arise within the business sector as well. It's something that I've certainly done throughout my career in public service and something that I intend to do as a commissioner on the State Corporation Commission as well.
Mr. Chairman, a comment. Having served under the Secretary of Natural Resources gives me no comfort based upon their predispositions and the responses you just gave me on that topic.
Mr. Chairman? A question.
Senator Eben.
Yeah, a question for Ms. Navarro. Just if you were selected for this position, how would what you bring to the commission be different than the other commissioner in place right now? What everyone brings different experiences. Can you just help us, let us know what gaps you might fill in or your perspective?
Thank you, Senator. I appreciate that comment and that question. So a couple of things that I think I bring to the commission that would be valuable, especially as it relates to this time in the commission. The first is through my service in both Secretary of Natural Resources and Secretary of Commerce and Trade, I've overseen a number of programs with a variety of state agencies, including Department of Housing and Community Development, Small Business, Virginia Economic Development Partnership, and a number of regulatory programs. So I understand how those programs are administered. The commission right now is administering a fairly significant program associated with providing rebates to individuals who are facing delinquency on their customer bills. So for example, we will be implementing a very significant financial program through our utilities. And those are the types of programs that I have helped to develop and implement in my service in the administration, whether it was the Rebuild Virginia grant program or a rent and mortgage relief program with federal CARES Act dollars. I understand how those programs are implemented and developed. And I think I can bring a degree of expertise and experience just in terms of the administration of those programs. So I think that's one thing that would set me apart from the other two commissioners on the panel, but I certainly look forward to working with both Commissioner Hudson and Commissioner Yagman and learning from them about their experiences as well.
Thank you, Mr. Chairman.
All right, thank you. Are there any more questions of Ms. Navarro? All right, where we are at this point, thank you, Ms. Navarro. We need I need a motion for a voice vote to find her, Ms. Navarro, qualified. All right, I have a motion and a second. All those in favor of finding Ms. Navarro qualified, please say aye.
Aye.
Opposed? All right. Thank you very much, Ms. Navarro.
Thank you, Mr. Chairman.
Okay. All right. We will start now on the calendar. The very first bill that is Senate Bill 1225, but that's on broadband services. That has to be re-referred to the Committee on Education and Health. So I would entertain a motion to do just that. All right, so move in second. This has to be a recorded vote. All those in favor of referring to Education and Health, vote aye. Those opposed, vote nay. All right.
That's
That's
15 to
taken
0.
care of. 1289, at the request of the patron, Senator Surville, has asked that that go by for the day. And without objection, that will go by for the day. All right. We need, no, okay. The next bill on the agenda is Senate Bill 1182, dealing with, that's by Senator Surville, dealing with motor vehicle liability insurance coverage limits. And you want to explain why we need the bill, Senator Surville?
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, you all might remember this bill from last session. This bill would raise Virginia's auto insurance minimums from $25,000 per person to $50,000 per person, and from $100,000 per incident to $100,000 per incident, and also raise the property damage minimum from $20,000 to $40,000. And so this deals with uninsured coverage, underinsured coverage, and it deals with property damage coverage. So we passed a similar bill last year out of the Senate that raised it to $35,000, 31 to 8, and this is a little bit higher, but It's where I think we need to go. So this number hasn't moved since I was 4 years old. 1975, Virginia's auto insurance minimum was set at $25,000. At that time, the average car cost $4,400. The average family made $11,800 a year. And if you use a time value of money analysis, $25,000 from 1975 would be $120,000 today. If you use medical inflation, because you remember that what this minimum policy is mainly covering is medical bills. If you use medical inflation, $25,000 today would be $262,000 today. And this number hasn't budged. There was a DMV study that was done a couple of years ago to look at this issue. And they estimated that by adopting this bill, the average automobile policy would increase by about 11% in its cost. So it's not a 100% increase by doubling the policy limit. It's only an 11% increase, which on a $700 a year policy is about 17 cents a day, or about $60 every 6 months, which, given what we just did on the minimum wage, which is taking effect in May, is not a big thing to ask of folks. If you look at other states, some people worry that this might result in people possibly going bare, that is, driving without insurance. One of the curious things about the DMV study was that the state that has the highest minimums in America, which is Maine, which is $50,000, which is what this proposes, has the lowest number of uninsured drivers in America. The state that has the lowest policy, $10,000 a year, Florida, has the highest number of uninsured drivers. So the data would tend to show that the higher the limit you have, the higher minimum policy you have, the fewer people go without insurance. So it actually has a positive effect. I would just note, for the sake of argument, that, I would also just note that the last 7 states to increase their insurance minimums, the uninsured rate actually went down, consistent with that. There was a Pennsylvania study that showed that. I would also note that in Europe, the minimum policy is $1 million, and we're at $25,000. So, and the last thing I would point out, for those of you who are fiscally conservative, is that our existing system hurts Medicaid. I asked DMAS to tell me how many claims they had over the last 3 years where they were seeking to recover a Medicaid lien off somebody who had a minimum policy. They told me that over the 3-year period that happened 113 times. So Medicaid asserted $4.2 million in liens against only $2.8 million in coverage, which means that taxpayers probably lost out about between $1 and $2 million of recoveries against Medicaid bills that we could have recovered from wrongdoers who hurt people because our policy minimums were too low. So by passing this, we will start to pass more of this cost on to bad drivers, the people who are causing harm to people when they get in collisions. Mr. Chairman, the last thing I would just say is that, that minimum policies, it's really a problem. There's a lot of people that this affects every year. Thousands of people. I would say probably at least 1,000 people a year probably are hurt because there's not enough money to cover their injuries. Medical bills have gone up tremendously in the last 40 years, and this will help to make sure that more people get their medical bills paid for and receive their fair sense of justice. And I believe there's people on the line that want to testify in favor of the bill and a few that are opposed.
All right. Thank you, Senator Surville. Are there any questions by the committee of Senator Surville? All right. We will go to each side will have 3 minutes. So keep that in mind when you're talking. If there's more than one of you, you'll be eating into somebody else's time if you go more than a minute. All right. Do we have people online ready to testify in favor of the bill? All right.
Mr. Chairman, I have a couple people texting me that they were unable to get in, but.
I see some now. All right. Mr. Dix, you go ahead. Mark Dix.
Thank you. Good afternoon, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we support the bill. I'd like to thank Senator Surville for bringing this measure forward. As Senator Surville noted, this law has not been updated since 1975. And the simple truth is that $25,000 in liability coverage is not enough today. It's not enough for lost wages, for medical expenses, and that's present, past, and future. That's $25,000 all in. That is all that is available to compensate victims of other people's wrongdoing. It's also not enough coverage for the tortfeasors. After $25,000, they're on the hook for that, and more people are going to be personally exposed. The sky is not going to fall by increasing limits to 5,100. Senator Somerville went through some numbers from the DMV study. Well, we obtained some data as well from the Independent Insurance Agents of Virginia, and they looked at the premium increases for State Farm, Nationwide, Progressive, and Travelers. That's about 45% of the personal lines in Virginia. And they calculated based upon a 19-year-old male and a 43-year-old male. The average increase for the 19-year-old male to go from $2,550 to $5,100 was $12 a month. For the 43-year-old male, the average increase was $3 and a catastrophic rise. As Senator Somerville also noted, there's no data to reflect there's going to be a rash of uninsured motorists. In fact, all studies have shown otherwise. Under the current regime, we're going to continue to see costs shift from fiscally irresponsible tortfeasors to the fiscally responsible victims. We hope it's the pleasure of the body to pass this bill. Thank you.
Thank you. Mr. Kirkner?
Thank you, Mr. Chairman, members of the committee. Andrew Kirkner on behalf of the National Association of Mutual Insurance Companies. I do want to leave adequate time for the other speakers who are in opposition to this bill, so I'll truncate my remarks. A couple things I would like to really impress upon the committee. The first thing is this. We're told that this is a slight increase, an 11 or 17%, depending on which number you go with. What's important to keep in mind for the members of the committee is who bears the cost of that increase. And that is, generally speaking, the people that are carrying around the minimum limits of financial responsibility. I am insured at rates much higher than that. I suspect many members of the committee and most folks that walk around are insured at much higher limits. So we're really talking about the folks that can afford to carry the minimum limits. So in effect, this bill in the middle of a pandemic would increase the amount of insurance that the folks at the lowest end of the socioeconomic status spectrum have in terms of their insurance. The second thing I would point out, Mr. Chairman, and I did send an email to all the members of the committee with the surrounding states' minimum financial responsibility limits. This bill, in no uncertain terms, would make Virginia the highest state in the country on minimum financial responsibility limits. It would bring us out of line with our surrounding jurisdictions, and again, would have a disproportionate impact. Thank you, Mr. Chairman. We urge a no vote.
Okay. Is there anyone else wishing to testify on the bill? I can't see the name.
Karen Addison.
Is that Karen Addison? All right, you're up.
Thank you. Good afternoon, Mr. Chairman, members of the committee. Karen Addison with Troutman Pepper Strategies on behalf of the American Property Casualty Insurance Association. We appreciate the conversations we've had with Senator Somerville. Unfortunately, we stand in opposition to Senate Bill 1182. As you know, Virginia's current law requires a minimum limit policies of $25,000 and $50,000 for bodily injury and $20,000 for property damage. We are not hearing any compelling reason to raise these limits. In fact, this bill would put Virginia as one of the highest in the country for bodily injury and property damage. As Senator Somerville noted, Alaska and Maine stand alone in their bodily injury limits of $50,000 and $100,000, and no other state has property damage limits higher than $25,000. Virginia's existing minimum insurance levels are well within the national norm. However, our members could support a measured increase to a proposal including a $30,000, $60,000 bodily injury and $25,000 property damage. This proposal's increase is consistent with our neighbors in Maryland and North Carolina. We just put that forward for the committee's consideration. Thank you, Mr. Chairman, for your time.
Mr. Chairman. Mr. Chairman, I have a question. I think it kind of relates.
No.
Mr. Chairman, I have a question relates to her comments, and maybe the patron or if Ms. Addison could come back on and answer this. If we did an inflationary adjustment, what would we be at?
Mr. Chairman, I'd mentioned that in my initial comments. If we used inflation based on the 1975 number, we'd be at 120,000 today. If we used medical inflation, we'd be at $262,000 today. And I would just note that if you're contemplating an inflationary adjustment going into the future, the carriers typically don't like that because they have to calculate actuarial rates to figure out loss histories and stuff to set their premiums. And one of the things we ran into last year is we picked a number that nobody else in the country had, and they didn't like having a unique number like that.
Thank you.
Hey, Mr. Bradshaw, you're going to be the final speaker.
Yes, sir. Thank you very much.
Wrap it up quickly.
Bradshaw with the Independent Insurance Agents of Virginia. And as Mark indicated, we did a lot of research on the filings and what the impact of the increase in the minimum limits would be. In general, generally speaking, we would support the increase as outlined by Senator Surville. Our issue would certainly be, though, with the public policy conflict where we're setting up the minimum limits, and yet for $500, you can pay a fee to DMV and drive around with no insurance whatsoever. And we think certainly would go with the minimum limits increase, but we really have to do something with the $500 and drive around with no insurance, because that is just setting up a tremendous number of vehicles where if you're hit, it's your policy that has to take care of the uninsured motorist claims.
Okay.
Thank you, Mr.
That'll be it for outside testimony. Any further questions by members of the committee? All right, need a motion.
Move to report.
Is there a second? Second. All right, you got a motion and a second to report Senate Bill 1182. All those in favor vote yea, opposed nay. Senator. All right.
Ayes 11, noes 3.
All right, the bill is reported. The next bill is Senator Obenshain's, and that's 1195. All right, this will go by temporarily. All right, Senator Peterson, Senate Bill 1202, you're up. Is he around? Oh, okay. All right, by temporarily. Oh, here's Senator Obenshain. Senator Obenshain, you're up on 1195. Motor vehicle insurance, underinsured motor vehicle. You want to explain the bill and why we need it?
Mr. Chairman, I would be happy to, although I was contacted by a representative of the insurance companies last night, and they asked if I would ask if this could be carried by for the day. Sure. As courtesy to them so they can process it. What it does is it allows the stacking of uninsured motorist coverage on top of regular insurance coverage to provide more protection to Virginians, but we can talk more about it next week.
All right, without objection, that bill 1195 will go by for the day. Senator Peterson's bill is temporarily by. So now we go to Senate Bill 1255. That's Senator Mason. Yeah. Oh, okay. And Senator Mason's bill deals with the State Corporation Commission and the issuance or renewal of insurance licenses or registrations during an emergency. Explain what the bill does and why we need it.
Yes, sir. Thank you, Mr. Chairman. Mr. Chairman, during the pandemic, the State Corporation Commission found that they were prohibited from allowing certain things to go on that outside of the scope of how they normally do it. So there was an agency in Virginia Beach that wanted to hire 10 new agents, but the testing centers were closed. So there was no temporary mechanism to grant them the ability to practice under another agent for the temporary period of time until the testing centers open. We had another example where a small agency, the agent died. And generally, they would grant a temporary ability for a spouse or someone to continue the operations, to continue to collect the premiums, to continue to do the business. either preparing to shut down the business or prepared for sale, and they had not contemplated the ability to do that during a pandemic. So, I'm sorry, Mr. Chairman, I'm trying to
So
bring
this
it
will
up.
give them the right to extend the time for, if your insurance has expired.
Yep, yes, sir. So if you look at the bill, the crux of it's on 19. It just speaks to the things that they would be able to do, waive requirements for issuance, temporary licensing, suspend examinations requirements, and then you see down next is they spell out when they would be able to do that, the nature and the basis of the emergency, the lines of insurance that it would be applicable. So this is the regulatory agency saying we would like the ability during a pandemic or a major emergency to announce that for this period of time, we're going to suspend these requirements and make it easier for people to continue to operate and do business.
Okay.
One of my colleagues did approach me about should there be a time limit, so I'm happy to discuss that as, they say for the next 90 or 120 days, and then it'd have to be reaffirmed. But remember, Mr. Chairman, this is the regulatory agency trying to figure out how to help people along during a tough time, and then would want to certainly come back to the requirements that they ask for on a regular basis. So that's the basis of the bill, Mr. Chairman.
All right, thank you, Senator Mason. Any questions of Senator Mason of Senate Bill 1255 by committee members? Senator Newman. Senator Newman.
Mr. Chairman, the question, I think, is on duration. I read on line 35 that it's duration of the order, but if they extended something, does the order that they extend continue on afterwards? In other words, if they extended something that goes for 2 years, when is the end of the order?
So, Mr. Chairman, Senator Newman, I had the conversations with them that they would say, as of this order, we would do it and would set a period of time. That's what one of my colleagues suggested, that in the order they say for the next 120 days, we will. But right now, it would just be under the terms of the emergency order today. So, but again, Mr. Chairman and Senator Newman, if you would like to see, I don't think, we can ask the folks at the SEC, but I don't see where they'd have an issue with noting a period of time and then coming back and revisiting it if necessary at that point.
Senator Marsden.
Need your mic?
Oh, here we go. Thank you, Mr. Chairman. I was the colleague that spoke to the senator from Williamsburg regarding a time limit. And I think one of the things that although it was a different circumstances when the governor was committing to certain emergency orders, they didn't have time limits on them. Some people were concerned about that. And I think putting in a 120-day time limit that is renewable, based on, evidence and what have you, would be appropriate here. I think it would give people some comfort that that decisions like this aren't being made on a permanent basis. And I would so move that we amend the bill in that manner.
Mr. Chairman.
Senator Mason.
Mr. Chairman, Deputy Commissioner Beavers is in the chat room to discuss. So I just kind of pulled those numbers out of a hat. So if we could ask him as he testifies, does this make sense? And is there some regulatory or industry timeline that we should follow? Rather, I like 120 days, but he might say for some reason it would be better for X days or Y days. So when he has the opportunity to testify, if he could speak to that, Mr. Chairman, and then maybe we could come back and determine a timeline that would work for everybody.
Is he going to testify?
Yes, sir. He's in the room.
Dave, why don't we wait, hear from him? Okay. All right. We need to see the lineup of those waiting to testify. Could you all raise your hands electronically? I don't see.
Mike Beavers, please go ahead.
Mike Beavers?
Good afternoon, Mr. Chairman.
All right, you got your for and against. Each side has 3 minutes. So transmit.
Yes, sir. Mike Beavers with the Deputy Commissioner with the Virginia Bureau of Insurance. in response to the earlier comment by the other senator, the duration of the order would be in the commission order as to the number of days that the Bureau would request. Generally, we anticipate it to be like 90 days, 120 days before we revert back to whatever the standard regulation is. We have no problem if you want to put in there that the order would have a 120-day duration and then could be renewed if necessary.
Okay. Thank you so very much. All right. Who's next? Who do you show next?
It's Bob Bradshaw with the Independent Insurance Agents of Virginia. And we represent over 5,000 independent agents throughout the Commonwealth. And we want to thank the SCC for working with us throughout this pandemic. And I was afraid Mike would stop taking my phone calls because I kept calling him with questions about, you won't believe this, how do we work together to get this taken care of? So we support this legislation and defer to the Bureau on the timing. I thought there was language related to that it had to be a time specific that it would run out, but we'll defer to the Bureau on that. But thank the Senator for carrying the bill and the Bureau of Insurance for working with us on that. Thank you.
Anyone else testifying in favor of the bill? All right, those who are opposed? No one. All right.
Mr. Chairman?
Senator Morrison, I guess you want on line 35, the duration of order, not to exceed 100 and add not to exceed 120 days.
Not to exceed, thank you, Mr. Chairman, not to exceed 120 days unless reviewed by the commission.
Okay. All right, you all have heard the amendment. All those in favor of the amendment, is that recorded?
Mr. Chairman, was that upon unless renewed by the commission or unless reviewed by the commission?
I think he said renewed.
Renewed. Okay, thank you.
All right, all those in favor of the amendment, vote aye.
Aye.
All right, voice is good. Opposed? All right, the bill is before you as amended.
Move to report as amended, Mr. Chairman.
All right, the motion to report, is there a second? And a second. All right, this is recorded. All right, all those in favor of reporting Senate Bill 1255 as amended, vote aye. All those opposed, nay.
Ayes 15, no 0.
Ayes 15, noes 0. All right, the next bill, hold on here, let me move these, is Senator McPike's. That's Senate Bill 1269, and at the request of the patron, he's requested it go by for the day. So without objection, 1269 is by for the day. All right. Next is Senator McClellan's bill. That's 1276. Is she online or nearby? Okay. Tommy, this bill doesn't mandate it, just takes out the bar. I think when we passed the Medicaid expansion, we prohibited abortion coverage.
Mr.
Yes,
Chair, I have two bills.
at public
Which
expense.
Which one would you like me to do first?
Let's take 1276 first.
Okay. It is on. Is that better? Okay. Senate Bill 1276 removes the ban on abortion coverage for any plan sold or offered under a health benefits exchange, which is pretty straightforward piece of legislation. The abortion is the only legal medical procedure that is prohibited by Virginia law from even being offered by private companies who sell plans under an exchange, and this bill would just remove that prohibition. It doesn't require anyone to offer one, but it does remove that prohibition. I think there are a number of people who have signed up to speak in favor.
All right. Any questions of Senator McClellan? She said, doesn't mandate just remove the prohibition that the company wants to offer insurance that the car company wants to offer. All right. Each side will have 3 minutes. Those for and those against. Show of hands electronically of all those waiting to testify. Remember, each side has 3 minutes. Each side has 3 minutes total. First, we'll hear from those supporting the bill.
Olivia Turner, go ahead, please.
I need a name. Olivia Turner. Ms. Turner, go ahead.
Senator, I'm actually in opposition to the bill. Would you prefer me to wait?
Well, hold on. Is there speakers first who are in favor of this?
Anna Scholl.
Thank you, Mr. Chairman, members of the committee. Anna Scholl with Progress Virginia.
Your name again?
Anna Scholl with Progress Virginia.
Okay.
We are strongly in support of Senator McClellan's legislation. We believe that, as she stated, abortion is the only legal medical procedure that is banned on Virginia's health exchange, which prevents individuals who are buying insurance policies from purchasing a policy that has comprehensive coverage for all of their reproductive health care needs. And that is a restriction that disproportionately impacts low-income Virginians and Virginians from communities of color and makes abortion less accessible based on someone's income or where they are purchasing insurance. So we would ask you to support the legislation.
All right, thank you so very much. Next, for the pro side.
Jamie Lockhart.
Couldn't hear
Thank
that.
you. Jamie Lockhart, Executive Director of Planned Parenthood Advocates of Virginia. We're in strong support of this legislation, and the current prohibition is the ultimate government overreach. It allows the government to dictate to the private sector what type of insurance coverage can be offered to private customers. This puts insured pregnant people in the position of having to pay for a potentially expensive procedure with out-of-pocket cost, a burden that many are unable to afford. We urge you to support today. Thank you.
Thank you. Next, for the pro side.
Tarina Keene.
Okay.
Good afternoon, Chairman Sasslaw, members of the committee. My name is Tarina Keene. I'm the Executive Director.
Welcome, Tarina.
I'm the Executive Director of NARA Pro-Choice Virginia. Thank you all for letting me speak with you today. We do support this bill. No woman plans on having an abortion, but when she does, it can be for many reasons. She could face an unplanned pregnancy, or her wanted pregnancy may put her own health at risk because she must undergo life-saving medical treatments such as chemotherapy, or because of a serious fetal anomaly. We cannot possibly know the circumstances of every woman who is making the deeply personal decision to have an abortion, because every pregnancy is different. And by limiting healthcare insurance coverage options, we limit a woman's ability to make the decision that is best for her, her family, and her particular circumstance. Abortion is an essential part of comprehensive reproductive health care and one of the most common and safest medical procedures performed in this country. And in fact, 1 in 4 women will have an abortion in her lifetime. But the Commonwealth of Virginia bans coverage of abortion care on its state health care exchange. Abortion is the only medical service on Virginia's exchange that actually mandates insurance companies not to cover.
Okay, time's up.
Thank you so much. We appreciate the help and hope you will support 1276.
Thank you, Tarina. All right, now we'll hear from the opposition.
Olivia Turner.
Yes, good afternoon, Mr. Chairman and members of the committee. As you know, I'm the president of the Virginia Society for Human Life. I'm Olivia Turner. We do oppose 1276 because we understand that what the removal of the prohibition could mean very quickly is that the citizens of Virginia would be required to pay for abortions under state-provided healthcare exchanges. Now, how do we know this? In 2016, when the Obama administration issued new Affordable Care Act implementing regulations, it defined discrimination on the basis of sex to include abortion. If that regulation had taken effect, it would have forced healthcare entities at the federal level who provided or paid for an abortion out of the program, because if they did refuse to pay for abortions, they would be seen to be in violation of the federal regulation. What this could mean in Virginia is that a similar regulation requiring abortions to be covered, otherwise facing a discrimination based on sex charge, would be an imposition on the people of Virginia who wish to purchase plans that do respect their ethical views and do not want to be seen to be paying for, with their tax dollars, paying for abortion under other exchanges made available in the Commonwealth of Virginia. So we are asking you to oppose this change in the law for the very simple fact that it's very well known taxpayers in general, whether they approve of abortion or not, do not want their taxes paying for it, nor should lower income individuals who are seeking these affordable care plans be forced to choose only plans that may end up providing abortions, whether or not they support them. We thank you for listening, and I hope you'll take the time to consider this.
All right, thank you. Next speaker in opposition.
Julia.
Good afternoon, committee. My name is Julia Sabanowitz, and I represent the Virginia Catholic Conference, which covers the 2 Catholic dioceses in Virginia, as well as almost 700,000 Catholics throughout the Commonwealth. As you know, the healthcare exchange in Virginia is taxpayer funded. Taxes pay for managing the exchange, and taxes pay for subsidizing healthcare plans. Taking away all restrictions on abortion is not what Virginians want. A Marist poll, it was taken in June of 2020. It found that 7 in 10, 70% of Americans, including nearly half who identify as pro-choice, want restrictions on abortion. The Hyde Amendment has been in place for decades. It's what the general population already agrees with, and this bill goes far beyond the Hyde Amendment. With this bill, you're compromising the ethical standards of individuals who are on the health exchange who do not support abortion. For those of us that affirm that life does begin at conception and that abortion is not healthcare, I urge you to please oppose this legislation. Thank you.
Okay, that wraps it up for the opposition. All right.
Mr. Chairman?
Mr. Chairman,
Bill. Senator McClellan.
if I can just add one thing, there were among the groups that do
Get closer to that.
Yeah, among the groups that support the bill that were not able to testify are the Whole Women's Health Alliance, Virginia Now, Catholics for Choice, Birth and Color RVA, the National Latina Institute for Reproductive Justice Virginia, and ACLU Virginia. I would like to respond to a point made by a couple of people in opposition. I can wait until after questions if you prefer, or I can do it now.
Go ahead.
So I want to make clear that this bill does not require exchanges to offer plans that cover abortion services. It merely eliminates the prohibition that they do so. If they do offer it, this bill does not require state or federal funding for those abortion services. Federal law is very clear about when federal funds can or cannot be used for abortion, as is Virginia state law. I will point out that for Medicaid covered patients, they can have coverage for abortions in the case of gross fetal abnormality. This bill, the current law would prohibit exchange plans from offering coverages for those same services. So this is not going to be a bill that requires any public funding of any abortion services. It removes a prohibition on what private insurance companies can offer through the exchange.
Right. All right.
Mr. Chairman, if it's appropriate, I've got a motion.
Senator Eben.
I would move to report.
Oh, wait, before we do that, anybody else desiring to speak? Okay, Senator Eben, you're up.
Move to report.
Sir. All right, there's a motion and a second.
Chairman, Mr. Chairman.
To report.
Mr. Chairman.
Senate.
Newman.
Senator Newman.
Mr. Chairman, I'm not going to support the motion, and the reason is because I do believe that the public has differing opinions as it relates to the pro-life, pro-choice position, but overwhelmingly, the public also supports the Hyde Amendment. And despite, I think, what the patron is very learned on these points, but the fact is that the state of Virginia and certainly the federal government, they do donate to certain individuals who are on the exchanges. That doesn't mean that they're necessarily going to pay for this service, but it certainly does go into the pot. So in my opinion, the concern I have is that the Hyde Amendment certainly will be at stake when we vote for this. And in fact, there will be funds, taxpayer funds, that will be used for a procedure that at least about half the country is very much opposed to.
Okay. All right, we got a motion and a second. All those in favor of reporting Senate Bill 1276, vote aye. Those opposed, vote nay.
Ayes 12, noes 2.
All right, ayes 12,
Yes, sir.
nays 2. All right, the bill is reported. All right, your next bill, Senator McClellan.
Thank you, Mr. Chair. The next bill is Senate Bill 1310. This is follow-on legislation from the Domestic Workers Bill of Rights that I had last year. Last year, that bill eliminated the exemption in the minimum wage law for domestic workers. There are many other worker protections that, since their inception, have excluded domestic workers. There are about 60,000, pre-pandemic, there were about 60,000 domestic workers in Virginia. It's one of the largest growing industries. It is predominantly women and women of color, increasingly Latina. What this bill would do is remove exemptions for domestic workers from the Human Rights Act, which are our anti-discrimination and workplace harassment laws, from worker protection laws regarding the payment of wages, the Virginia Workers' Comp Act, and that is the bill.
Mr. Chairman. Mr. Chairman, I would ask the patron, am I correct in understanding that, that say somebody who has a need for a home health aid or personal care aid maybe winds up having to have it around the clock? I think of my in-laws who needed it out in the Shenandoah Valley, and they may have had to have hired 3 people to fill different shifts. Does that mean that they are going to have to get workers' comp coverage for their home health aides or personal care aides?
Yes, under the if you look, I think the workers' comp provisions start on lines 282. And the definition, yes, the definition of domestic service for workers' comp would include a home care aid, I believe. I'm trying to find that language.
So I guess, Mr. Chairman, my question is that while workers' comp traditionally is something that businesses wind up having to get, this is going to impose that requirement on individuals and families, and I guess I wonder whether that's just going to cause more under-the-table arrangements rather than achieving the ends that the patron wants, particularly with respect to the workers' compensation coverage for those categories of help and assistance.
The question I would have, is there an hours requirement? In other words, suppose somebody had somebody 1 day a week or a half a day a week. Would this apply? Would they have to pay into workman's comp?
What the bill does in the workers' comp section is redefine, what the bill does is redefine employer to include anyone who engages an individual to perform domestic service. Whatever other laws apply to an employer under workers' comp would apply to an individual or a family that engages an individual to perform domestic service. So I don't know off the top of my head if workers' comp has a particular hours requirement. If it does, it would apply here.
Mr. Chairman.
Any labor lawyers here?
Mr. Chairman, Surville.
Surville.
Thanks, and this might be more of a question directed to our counsel. Is it Tom Stevens, I guess? But my understanding of the workers' comp statute in Virginia is that you have to have, I think, at least 3 employees before it kicks into you, and maybe he could confirm the interplay of this statute with that 3-employee requirement, both, and I think it's whether they're part-time or not. I think it's just if you're paying 3 people to work for you, that's when workers' comp kicks in.
Mr. Chairman, Senator Sasslaw, yes, 3 employees or more.
3 or more employees.
Vote 3.
Okay. So it wouldn't apply to one individual working in a house.
Our intention is that it would apply to a domestic worker.
Mr. Chairman.
Hold on a second.
Then you're
That's
changing
just
the workers'
the opposite of what you just said.
Mr. Chairman.
Senator Surville.
Thank you. Mr. Chairman, I believe with regard to the way counsel just confirmed that a workers' comp requirement would not apply or would not arise in this situation unless the person employed 3 or more people in this category. So, for example, 3 combination of housekeeper, cook, driver, gardener,
Right.
et cetera. However, Mr. Chairman, I would note that the way this is worded, for example, some of the other non-discrimination laws that we just passed last year, which normally only apply to employers that have 15 or more employees, would now apply to somebody employing 1 person. So, for example, if you fired your maid or your cook or your driver or your gardener because of their race, their sexual orientation, their gender, et cetera, you could now be sued under that employment discrimination statute for that, I believe is what the bill does.
So it would apply to 1 person,
For some statutes, Mr. Chairman, but not all of them.
but not workman's comp.
Not workers' comp, I believe is what Mr. Stevens just confirmed.
Okay.
Unless they employ more than 3 people.
3 people.
But, Mr. Chairman, over here, open chain, but that includes if I've got somebody who works, or 3 students who are coming in, somebody who works from 8 to 11, then somebody comes in, helps with dinner, and then somebody else comes in overnight, that would be covered. Even if they work 2-hour shifts each, you've got to get workers' comp coverage.
I guess.
So,
Mr. Chair.
You got to do that now.
No.
Mr. Chair, Senator Obenchain raises a really interesting point I'd like council to address. If I've got somebody coming in to help me cut wood 1 day a month, and I've got somebody else coming in to help me with plumbing 2 days a month, and then I have somebody else to come in and help me feed the horses so I can be in Richmond 4 days a week, am I suddenly subject to the workers' compensation if any of those people is classified as a domestic employee?
Mr. Chairman, Senator Deeds, I'm going to have to check on the part-time versus full-time employees, but I would note that some of these examples that are given, they would be independent contractors rather than employees.
Right.
Mr. Chair, if it helps, on line 374, it says lines 371 to 375 define what domestic service is. It does not include work that is irregular, uncertain, or incidental in nature and duration.
I can't hear you. You got to.
Domestic service is defined for the workers' comp provision on lines 371 to 375, if that helps. If they are already in, and if you hire a domestic worker from an agency, they are employed by the agency and they are already covered by workers' comp. If you do not hire them from an agency, they are not covered by workers' comp.
Mr. Chairman, would that apply if they were independent contractors for the agency? I would submit not.
Mr. Chairman, Mr. Chairman, Becker.
Go, Senator Bill.
It's a question I would have. It kind of goes on this independent contractor thing. Let's say I have somebody who does my lawn care, landscaping. It's a company I hire, but their workers maybe is not disclosed to me that they're independent contractors, not employees. Would I have a duty then to find that out?
Landscapers are not included in the definition of domestic service.
But, Mr. Chairman,
Senator Bill.
gardeners, other lawn care, leaf removal, would that not be included?
Not as I read the definition, no.
Mr. Chairman, Lewis back here. It seems to me we're going around in circles here, and this is a short session, and I think there are a lot of questions here about unintended consequences, and I would suggest, ask, move that it maybe go by for the week.
All right, is there a second? All right. All those in favor of it passing by for the week, say aye. Aye. All right, opposed? All right, it's by for the week or the day.
Thank you, Mr. Chair, members of the committee. This is Senate Bill 1202. This deals with bad faith claims against insurance for underinsured or uninsured motorist policies. We've had in the law for years that when you make a claim against a defendant and they are covered by insurance and the insurance company does not cover the claim and their refusal to do so is in bad faith, that if you go to court and get a recovery, you can not only get the amount of that recovery, but also get your attorney's fees. And that's been the law for years and years, and we're all very familiar with that. Of course, many, perhaps most claims these days are not against your opponent's insurance company, but rather against your own insurance company. Let's say you get in an accident with somebody that's either uninsured or underinsured, because, of course, the maximum policy is capped at $25,000, so most claims will be over that. So what this law allows that is simply to take that same concept that we've had for years and apply it to your own UM or UIM coverage. And the language is very arcane. I'm not a huge fan of the language in the bill, but the concept is simple. It's just taking that bad faith concept and extending it to UIM claims against your own insurance carrier. And I know Virginia trial attorneys, and I'm sure some other attorneys would like to speak to the bill. And that's 1202. Dick, I've done my piece, and I think there's some folks that want to speak.
All right. First up, on the pro side, you have 3 minutes on each side. Not 3 minutes per speaker, 3 minutes per side.
Andrew Kirkner, please go ahead.
Mr. Chairman, I'm opposed to the bill, so it may be somebody else.
Jeremy.
Mr. Kirkner, are you finished?
Mr. Chairman, I'm opposed to the bill. I'd be happy to speak now, or if you'd like me to wait.
All right. You gotta run the clock.
Hi, this is Jeremy Flax. I think I heard my first name, but I was going to let Mark Dix go first. Is that all right?
Mark, you're up.
Thank you, Mr. Chair, members of the committee. Mark,
are you speaking in favor of the bill?
Yes, Mr. Chairman.
Okay.
I represent the Virginia Trial Lawyers Association, and we support the bill. We'd like to thank Senator Peterson for bringing the measure forward. Currently in Virginia, there is only one type of first-party auto insurance that has no duty to act in good faith with their own insureds, absent a judgment, and that is the UIM carriers. Your own underinsured motorist carrier has no reason, no incentive to negotiate in good faith when you seek to access your UIM coverage. Instead, they can force you to litigate a personal injury claim all the way through trial and obtaining a judgment for no reason or any reason that they see fit. And that is what we are seeing from UIM carriers presently. Low ball offers, no offers. This bill will place UIM carriers on the very same footing, with the very same duties as every other insurance company. We hope it will be the pleasure of the body to pass the bill. Thank you.
Okay. Anyone else speaking in favor of the bill? All right.
Jeremy Flax.
Thank you, Mr. Chairman. Committee members, my name is Jeremy Flax. I'm the attorney that litigated the Manu v. Geico case that's referenced in some of your paperwork. I had a client who had catastrophic injuries that overwhelmed the insurance coverage available from his own insurance company. And his own insurance company basically looked the other way because they could. They refused to make any kind of an offer. We had to go to trial. We spent a lot of money. We got a judgment for more than the amount. Insurance company then paid after about a year of delay and after all the expense, what they should have paid at the very beginning. As Mr. Dick said, uninsured and underinsured motorist claims as a result of this Manu decision are the only types of insurance coverage that are not sanctioned for bad faith conduct. We thought we had that covered with the legislation 8.0166.1D1, but the Supreme Court said no, the legislature didn't write the legislation properly. And so we want to close that gap. And I consider this a consumer protection bill. Thank you very much.
All right.
Joe Hudgens.
Next speaker in favor of the bill.
Joe Hudgens, please go ahead.
I'm sorry, I was going to speak in opposition to the bill.
Okay, your time's coming, hold on. Anyone there in favor? Your time, 10 seconds.
Clark Lewis.
I likewise, Mr. Chairman, am opposed to the bill. Sorry.
Okay, all right, now the opposition to the bill. You have 3 minutes total.
Mr. Hudgens, go ahead. Okay.
Good afternoon, Joe Hudgens. Joe Hudgens with the Independent Insurance Agents of Virginia. We just feel like that this tips the scales away from what would ultimately become a fair settlement. Does this by shifting the company's attention and determining their offer to not what's fair or appropriate, what a third party determines is reasonable, whatever reasonable means. The other point I would make is under 38.2-500, under the unfair trade practices, that section is where we talk about fair claims practices. And if something like that is brought to the Bureau of Insurance, they can take action. That's basically all I have to say.
Andrew Kirkner, please go ahead.
Thank you, Mr. Chairman, members of the committee. I'll try to be brief. I know our time is short. One thing I do want to clear up for the committee that was said in earlier testimony is that insurers have, quote, absolutely no duty to act in good faith. That is not correct. Insurers do have a duty to act in good faith under existing statute on claims below $3,500. My understanding of what this bill would do is to, in essence, lift that de minimis cap below which bad faith culpability can be found. The problem, Mr. Chairman, in part is the way that the bill is drafted. Insurers are asked to act in good faith, but the definition of what would constitute bad faith is very, very poorly laid out in the bill. For example, insurers are required to accept a quote unquote reasonable settlement offer. There's no language around what would be a reasonable settlement offer or what would constitute such an offer. They're also asked to accept that reasonable settlement offer within a quote unquote reasonable time, again, an undefined term. We're concerned that insurers are being asked to meet an impossible threshold here. And the bottom line is this will raise the cost of insurance. Thank you, Mr. Chairman.
Clark Lewis.
Okay, next.
Mr. Chairman, Clark Lewis, Troutman Pepper Strategies, representing the American Property Casualty Insurance Association. We oppose the bill for many of the reasons stated. I will mention that this would be a major extension of Virginia insurance law and would increase rates for our member companies. There was a mention about the Bureau of Insurance handling the complaints. We checked on that, and between November 2017 and November 2020, the Bureau received 38 consumer complaints regarding UM/UIM complaints. These were claim denials, claim delays, or unsatisfactory offers. They were concluded with the company position be substantiated or compromised resolutions. Most importantly, with no unfair claims violations found. We simply believe that the current system works, and we appreciate your consideration in opposition to the bill. Thank you, Mr. Chairman.
Okay, time's up. Any further questions of the sponsor from the committee?
Comment.
Senator Norman, comments.
A question or two of the patron. Would you consider a friendly amendment to, one, put an emergency clause on it, and secondly, to put a treble damage award of attorney's fees if there is a bad faith claim?
I'm going to say no, although I like the emergency clause idea, and I'm going to explain why in a second. But
you need 80% of the votes.
I know. At this point, let me just get the bill passed.
Thank you, Mr. Chairman.
Yep.
Mr. Chairman. Surville.
Senator Surville.
Thank you. Speaking to the bill. Mr. Chairman, this bill is addressing a really big problem that we have out there. And, you know, as somebody who's practiced law now for 24 years, this is something that's been missing from Virginia law that exists in almost every other state. And it was interesting to me to hear that that the industry is worried about the language of the statute. I just went for curiosity and looked up Pennsylvania's bad faith law, and it's got about half as many words and doesn't have reasonableness or anything in it. This thing has more protections for the carriers in it than most other states. And what we're talking about here is how your insurance company treats you. You buy a coverage in case somebody hits you and they don't have enough coverage. That's what we're talking about. And right now, your carrier doesn't have a good faith, an obligation to treat you in good faith if somebody else hurts you. They only have that obligation if you hurt somebody else. It's crazy, and it's totally backwards. And so I think it's time we caught up with the rest of the country and had some laws that set the incentives right so that if somebody hurts you, that you have the ability to access the insurance that you've paid for. Because right now, you can only ever get that policy if you take your case all the way to trial, which is crazy and expensive, and it doesn't make any sense. So I would hope we would support this.
Mr. Chair.
All right.
If I might make just a closing comment.
Sure.
Mr. Chair, members of the committee, I wanted to wait until the end. I had a personal story. I represented a client. It was a woman that went to my church who was in her late 70s, who was in an auto accident, and afterwards was disabled, could not move her right arm. She had almost $100,000 in medical bills. And the young man who was driving the other car, they immediately posted the limits. So the limits were up, and at that point, we had to get a recovery against her own policy. She had made every single insurance payment for probably 50 years. And they delayed it, and they delayed it. We were supposed to go to trial last summer. Of course, jury trials were canceled. I said, I'll do it in front of a judge. I'll do it in front of a high school gym teacher. I don't care. I'll do it in front of anybody. And they said, no, we want a jury. So at the end of the day, I had to compromise her claim down to, frankly, I don't want to say pennies on the dollar, but I was afraid that she might pass before I could finally get a recovery for her. And that's what happens when you don't have a bad faith leverage against these companies. That's what happens. So anyways, I think it's a good bill.
All right. Is there a motion?
Move to report.
All right, the motion to report. Is there a second? All right, comments? No comments? All right. Ready for a vote? All those in favor of reporting Senate Bill 1202, vote aye. All those opposed, vote no.
Ayes 14, noes 0. I'm sorry, noes 1.
1. All right. Okay. All right, let's see where we are here. Aaron, Barker. All right, looks like we are up to 1159, Senate Bill 11:59. That's Senator Favola. He's coming through the door. 11:59 is, doesn't mandate it, but it said essentially if you have sick leave, then you gotta let them use some of that for if somebody in their house gets sick. And it's only for people with more than 25 employees.
Well, good afternoon. Did you want to hear 11:59 first? Okay.
You know, you gotta get closer to that if you're gonna keep your mask on,
Okay.
okay?
Yep. Okay. So
You wanna do 11:59 first?
yes, sir. All right. It's a very, very straightforward bill. What this says is, if you happen to be an employer with 25 employees or more, and you offer paid sick days to your full-time employees, you have to allow those full-time employees to take up to 5 days to care for a family member.
As part of that, but it would count against their sick leave.
It would count against their sick leave. We are not asking for any additional leave. There's no additional expense in here. Companies have already budgeted for this. We're merely saying you need to be flexible. There are a number of studies out that show if parents can't take leave to take their children to a doctor or to get their children vaccinated, there are a proportionally higher number of flus and other illnesses in that school. That's the primary reason, but there is no restriction in this bill on what the leave could be used for, as long as it's used to care for a family member. So, and this could be a, female or male employee. You could be taking an older parent to the doctor's office, et cetera, et cetera. That's the bill. So I just want to reiterate, there's no new mandate. Now, you will hear from folks I might as well address this up front. There are two lobbyists, each one represents an airline, and they wanted a carve-out under the Railway and Labor Act, so to just carve out the airlines from this, whatever mild requirement this bill might have. And of course, our friends in the labor side are really pretty adamant against providing a carve-out. We've gone back and forth on various possible amendments. My bill does not offer a carve-out.
First, Senator Obenchain.
Just, I had somebody who flagged this and asked, how do you confirm that somebody is an immediate family member if they say, I'm taking this day off to care for an immediate family member? Under the definition, can they require the employee to produce their income tax returns?
It would be entirely up to the employer. We don't dictate in this bill what verification might be needed, what accounting might be needed. That would be entirely up to the employer.
Mr. Chairman, but doesn't it say that immediate family member is a person identified as the employee's dependent upon the employee's most recent federal income tax return? Doesn't that give the employer the ability to demand to inspect their federal income tax return?
If the employee if the employer wishes, Mr. Chairman, if the employee wishes to.
Okay.
That would be one way of doing it.
Mr. Chairman. Mr. Chairman, may I suggest to the patron, that's a really bad idea to say that an employer has the right to look at the employee's W-2s or tax forms. I don't know how else you do it, but that's a really bad way to do it, because I, as an employer, and we have 500 employees, I would never think of doing that, but this may be the only way to do it. I have other concerns about the bill, but I would really urge you to think about Senator Obenchain's question about allowing an employer to look at employees' tax returns.
Well, I, as an employer, would not do that. So, like, an employer would have that option.
Thank you, Mr. Chairman. Senator Favola, we talked the other day, and if a collective bargaining agreement between an employer and its employees didn't have any of this in there, would this trump that collective bargained agreement?
I would ask General Counsel to answer that. I believe it could, but I will ask General Counsel to answer that.
Mr. Chairman, Senator Favola, Senator Marston, yeah, this would apply to any employer that provides sick leave. That's under a collective bargaining agreement or through their own company's HR policy.
Thank you.
I just want to reiterate, this would be a floor. It's not a cap. It's a floor.
Mr. Chairman, that was kind of along the lines of my question is, if you had an agreement in place, it could be better than this, or I guess I don't understand why you wouldn't carve out folks that, I see what you're trying to do. Use, if you have it, be able to offer it, and I think we should look at better ways, as Senator Newman pointed out, that you indicate who the local family member is. But I guess the question is, why wouldn't we carve out airlines, which is the one that has come up year over year, who have an agreement in place, it may be better than this, but it's already been negotiated. I just worry why we'd put that at risk.
Well, if there's an agreement that's better than this, then this bill is moot. I mean, if the agreement's better and offers that flexibility, then this bill wouldn't affect it. I guess the question continues to be, when you talk to the labor people and you talk to the Railway and Labor Act people or the airlines people, the definition of an airline employee seems to be really, could be murky. The National Mediation Board makes a determination about whether an employee is an employee of the airline, and one of the criteria has to be how much control the airline exercises over that employee, whether they're a direct employee, whether they're a contractor. There doesn't seem to be a lot of decision law on that or case law on that. So folks who are really worried about not having access to this benefit are concerned that they could get caught up in a decision that would claim a subcontractor in effect was an employee of the airline and therefore would not be eligible for this.
Mr. Chair.
Now, that's a whole area of debate.
Mr. Chair. Senator Favola, I'm really interested in that statement you made that this is a floor. If this applies to every employer, and you've got somebody who potentially has a collective bargaining agreement that provides a more generous benefit, why wouldn't this replace that?
This would be viewed as a floor.
Where does it say that? Point me to the language.
It doesn't say it'd be a floor, but I think the expectation is that if you already offer, we're not changing the sick leave. If you already offer sick leave, no matter what it is, we're just asking for flexibility. We're not saying how much you should offer. We're saying if you offer it, then you need to provide flexibility. And it says that you could I believe you could take up to 5 days. Allow an employee to use more than 5 days of earned sick leave per calendar year for the care of an immediate family member. This is only asking for flexibility. It's not putting an additional burden on how many sick days you're granted. It's not telling you have to offer sick days. It's just saying if you do offer them, then you need to provide this flexibility.
Mr. Chairman, back here. Mr. Chairman, my question for the patron, would you be willing to consider a friendly amendment? I believe the issue, especially the way it's worded in relation to the federal income tax return, is problematic.
Okay.
Because, I mean, with it saying employee dependent upon the employee's most recent, I think it really begs for employers to possibly have to look at that. I mean, if I think about the hardship reasoning we use to justify going into a plan with landlords, that was just based on an affidavit. Perhaps we could revise this language to make it less onerous.
I am happy to offer, I'm happy to say an immediate family member means an employee's child, spouse, grandchild, grandparent, parent, or any, and put a period there. If that's your friendly amendment, I can accept that.
Mr. Chairman, I would make that amendment.
Mr. Chairman, my understanding is there'd be a period after the word parent.
Mr. Chairman, for council, if you're tracking, I don't have the line numbers on here, but it would be, or other individuals, let's see, actually right after parent, the word parent.
Chairman, Senator Bell, so that would read immediate family member means an employee's child, spouse, grandchild, grandparent, or parent.
Now, what we're not including, if we do that, to be clear to the patron, would be or other individuals identified. So if there's a niece, nephew, or other person, if you want to address that, we would have to add that on.
I'm fine keeping this more narrow. So if it is your preference, Senator Bell, Mr. Chairman, it's your preference, Senator Bell, to say immediate family member means an employee's child, spouse, grandchild, grandparent, or parent, I'm okay with that.
Mr. Chairman, I would move that.
Mr. Chairman? Mr. Chairman? Just a comment on that. Would we need to add something here about a child who's in the custody of those individuals? A lot of times people have a niece or a nephew in their custody for whatever reason, in foster care or whatever. Would it be necessary to add that as well? I would direct that question to council.
Mr. Chairman.
Senator Bell.
I'm going to withdraw my motion. I think it might be better to pass this by for the day and to look into this and work this, because I like what the bill is doing, the flexibility. As an employer, I'd be happy to do this for my employees, but I think maybe we need to think this through and not do it on the fly so we get this right.
All right. You've heard, yeah.
In support of that motion, I would like to speak to it and say, Senator Deed's last point is one I think we need to clear up. If you're subject to a collective bargaining agreement, would this now supersede it and you would only have to do this? And if there's a question about employees, particularly with the airline, it seems to me you'd either be subject to the agreement or not, and that would be the defining line. But so I would just want to make sure we don't lessen someone's benefits that are already negotiated and or not tamper with previously negotiated agreements while trying to get at what you're trying to get at here.
I appreciate that, because this intent was that this be a floor. I'm happy to take it by for the day if that's the will of the committee.
All right, we'll take it. All right, you all have heard the motion. Bye for the day. All those in favor say aye. Aye. All right, it's bye for the day. The next bill is 1219.
Okay. This is really simple. Goodness, 7 lines. Oh, I thought we could deal with it. Okay, so this bill does 2 things. First, it's a study. It's a Section 1 bill. It directs the State Corporation Commission's Bureau of Insurance to review whatever might be necessary, either statutory change or regulatory change, to authorize the state to approve the sale of individual and group paid family leave plans. So right now, if you're an insurance company and you want to offer a paid family leave plan in Virginia, you can't do it. You don't have the authority to do it. So this bill merely directs the Bureau of Insurance to figure out what's needed for that to happen. And then the second thing this bill does is it asks the Bureau to sit down with stakeholders, convene a group of stakeholders, and they're mentioned here, the business community, insurance industry, advocates for paid family leave, and come up with recommendations on what incentives, if any, would be needed for an employer to voluntarily offer paid family leave for up to 12 weeks. A report is due back to Committee on Commerce and Labor and Finance and Appropriations.
By November 30th.
By November 30th.
All right.
Mr. Chairman.
Questions?
Mr. Chairman.
Senator Newman.
I guess my question is why are we giving them a time period? 3 months is a very, very long time. Why are we giving them a time period if they're going to study it? In other words, shouldn't they study it and say, come back and say, you know, that 5 weeks is the limit that would be injurious to business? In other words, why are we telling them what the outcome needs to look like while we're studying it?
Well, I wouldn't phrase it that way. We would say that, or what this bill would say, is what would be needed to offer 12 weeks. If the recommendation comes back and says companies really can only afford to offer 5 weeks.
Why don't you say up to?
Yeah, we can say up to.
Up to, Steve, would that take care of it?
That's on line 15.
Yep.
Second that amendment, Mr. Chairman.
All right, you've heard the amendment.
Two.
It's going to be up to, instead of just offer 12 weeks, up to offer up to 12 weeks.
Yep.
All those in favor of adding the amendment, say aye. Aye. Opposed? All right.
Mr. Chairman, Surville.
Senator Surville.
Thank you, Mr. Chairman. I had I guess a process question for you, Mr. Chairman. So, you know, I've been involved in state SCC work groups before over specific issues, just based on the chairman of a committee writing them a letter. And so, do we normally do this by a Section 1 bill directing them versus, you know, asking them to just do it? I mean,
we can do it either way.
Right. Okay. Just don't have your. Okay.
Mr. Chairman.
Senator Newman.
I think Senator Surville's correct, and I do think for the patrons' purposes, I think you get to the House, that's been their position forever. So getting a Section 1 study is not a good thing to take over there. I would think that Senator Surville's correct, that a letter from the chair would be the appropriate mechanism.
Mr. Chairman, I do have a couple speakers. I'd like to hear you may want to hear their.
What?
I believe there are a couple speakers who've been very interested in this bill. You may want to hear their view on.
All right, we'll give them a shot, and then we'll come back to the discussion again. All right, first up, for those who support the bill, each side has 3 minutes.
Nicole Riley, please go ahead.
Good afternoon, Mr. Chairman and members of the committee. Nicole Riley with NFIB. Just very simply, we support the bill. We think this is a good step forward in looking to see what options are available in the private market. We certainly leave it up to the committee on the process by which we get the study done, but that is the important piece here, is to do the study. Thank you.
Patrick Cushing, please go ahead.
Yes, Mr. Chairman, members of the committee, Patrick Cushing with Williams Mullen on behalf of the American Council of Life Insurers, and we worked with Senator Favola to bring this bill forward. We support the bill. What we have found out from the life insurance industry, which supplies family leave products in other states, is that when individual insurance companies recently have approached Virginia to sell family leave plans to employers who are interested in purchasing them, the Bureau of Insurance notified us that they are unable to approve the sale of these plans in Virginia. So we've worked with the Bureau of Insurance on this issue, and I think they're ready, willing, and able to take a look at what changes in the code and regulations may need to be made to authorize this sale. This is, I think, a win-win for moving the ball forward and getting more access to family leave plans for employees in the Commonwealth. So we urge your support in the bill and hope you would vote for it. Thank you.
Clayton Medford.
Mr. Chair, Senator Favola, members of the committee. My name is Clayton Medford. I'm speaking on behalf of Northern Virginia Chamber of Commerce's 700 members and close to 500,000 employees in favor of this bill. I want to thank Senator Favola for offering to explore opportunities for the ways that the Commonwealth can incentivize this kind of benefit rather than mandate it, and hope you support the bill. Thank you.
Karen Addison.
Thank you very much.
Thank you,
Karen
Mr.
Addison.
Chairman. Thank you. Good afternoon, Mr. Chairman, members. Karen Addison with Troutman Pepper Strategies, representing AFLAC. Also wanted to express our support for the bill and our gratitude to Senator Favola. We support exploring a regulatory framework for writing these policies at the Bureau of Insurance, and we appreciate your support.
There are no more speakers.
Mr. Chairman? Mr. Chairman?
Anyone against?
Mr. Chairman?
No. All right.
Mr. Chairman?
The bill is before us. We can do it by the bill, or I guess you would have to, the motion would be to pass the bill by, if you send a letter. Quite frankly, I can do either.
Mr. Chairman?
Mr. Chairman, I don't embrace the bill, but I don't wish it any harm. And I would just say the patron may want to think about it, because Senator Servell was right about the protocol of the House, and it may very well place it in jeopardy over there.
Mr. Chairman, I would just ask if I can certainly accept a letter, but I would like it to have everything in it. My experience as a committee chair is the staff usually write the letter, and it's not very robust. So when the letter gets written, I would like the contents of what's before us to be in that letter. If you can assure me that's the case, I would be happy with that.
Mr. Chairman? Mr. Chairman, question? To make sure we're safe, would it doing a harm in doing both, get the letter read as well as passing out here and there? Or doing a harm in doing both? Could we do both?
I suppose you could do both.
Well, I'm saying because sometimes the letter may not be suffice. So I'm saying that if you got the both together out here and there and have a letter on the standby just in case.
I would move that we report the bill as amended, and that if the chairman wants to write a letter in addition, that would be fine.
A second.
All those in favor of reporting this with the amendment, that's the one that says up to 12 weeks, vote aye. All those opposed, vote no.
Ayes 12, noes 3.
If anything happens to your bill in the House, then I will send a letter.
Very good. Thank you, Mr. Chairman. I appreciate your time, and we will work on 1159, and please put it on the docket for next week. Thank you.
12-3. Godfather, you helping somebody? Praise the Lord.
We now move to Senate Bill 1330. That is Senator Boysko's bill dealing with paid family and medical leave, requires BDC to establish and administer a paid family and medical leave program with benefits beginning January
Mr. Chairman and members of the committee, I have okay, can you hear me now? Great, thank you. Mr. Chairman and members of the committee, I present SB 1330, which would institute a statewide paid family and medical leave program. We know that we have seen this past year how vulnerable people are when they're faced with a health emergency, and it happens to all economic levels. Watching the pain of a loved one dying or struggling to make a decision between going to work sick or losing their job. And here in Virginia, we are very proud of and we work hard to maintain our strong, welcoming business environment. This is a bill that actually strengthens businesses by pooling small contributions together to build a fund that will pay benefits for individuals, eliminating the burden on any one company. This legislation makes it possible for businesses of all sizes to afford up to a 12-week paid family and medical leave program for their employees. Small businesses and their employers have been hit particularly hard by this pandemic, and this is a policy that will support and strengthen our small business community, contrary to what the opposition will say. So let me tell you what's in the fund, what it pays for. When people make their small contribution each month, if they need help, they get 12 weeks off with the insurance paying their salary, a portion of their salary. The company has to pay nothing for dealing with a serious medical condition, which would be verified and would have to get permission for it. Caring for a loved one with a serious medical condition, same applies. Caring for a service member in our military families during illnesses and deployments. Caring for a new child. Employers, I know, face difficult choices. I just had a conversation with one of our colleagues who said even some of these small businesses who have nonprofits feel like they couldn't afford to have paid family and medical leave. If they were to just do it out of their own pocket, paying even one employee during a period of this necessary absence would be more than they would be able to afford. But with this program, employers of all sizes would not have to make that difficult choice between paying their highly trained, valuable employees or figuring out a way to replace them. This will help, actually, and I've heard from some of the bigger businesses, the expenses for a business's bottom line. So let me explain a little bit about why I brought this before you, because this program works. Around the entire world, the United States is the only industrialized, modernized country that does not already have a paid family medical leave program in place. And, you know, in Virginia, I'm hoping that we will get there. 8 other states have already done this, including New York and California, which happen to have pretty robust economies and have not had adverse effects, and the District of Columbia. They have long track records of success, and we are following their lead and their guidance on what works and what doesn't work. We know that federal law guarantees unpaid leave, and not everybody is even able to do that. And so I am hopeful that you all will give serious consideration to this paid family and medical leave program. I'm grateful for the support of the Virginia Campaign for a Family-Friendly Economy and the Main Street Alliance. The Main Street Alliance is a group of 30,000 small businesses that are advocating for this bill, and they will be here to speak to it. I also have some experts here who have been working at the national level to help implement this in other states, and they can answer the technical questions you may have. Some of the other organizations that have signed on as coalition partners are the Virginia Breast Cancer Foundation, SARA of Virginia, which is the Substance Abuse and Addiction Recovery Alliance, the Virginia Hemophilia Foundation, the Hemophilia Association of the Capital Region, and Vocal Virginia. All of these are patient advocacy groups that recognize the need to remove the barriers. And I hope it is the pleasure of the Senate to report the bill, and my witnesses are on the phone, and we'll be happy to answer your technical questions. Thank you.
Mr. Chairman.
All right.
Mr. Chairman, I guess my question is, I understand and read the bill, employers will pay for it, but they'll pay for it through increase in their premiums. Is that correct?
That is one way. We could change that. So there are states where the employee pays for the whole thing, which would be about 0.5% of their salary per paycheck. We have the ability to do this the way that works for Virginia.
Oh.
But the important thing here is that it's universal, so that it would be, inexpensive enough so that everybody could afford it at that low rate.
Mr. Chairman, just to follow up, sir. Just to follow up, but as it is written today, the employers are going to get about a $2 billion brand new bill on unemployment unless the federal government comes through and pays our debt, right? It's going to be massive, right? And this would be on top of that as written. My thought, and maybe it's at some point, if we're going to require this, because big businesses, we all have it, right?
Right.
My company,
Right.
we got it. We're taking care of it. It really is, it's hitting the small businesses. It ought to really become a state plan that we pay for, right? That the Finance Committee says, here's the $200 million, we're going to pay for it, and that becomes a plan that I think makes sense. But as written, I have deep concerns that we got about a $2 billion assessment that's coming to our employers who somehow made it and survived, and now this will be added on top of it. So that's a concern.
And Mr. Chairman and Senator Newman, I appreciate the fiscal concerns about it. I, understand that with what's going on right now, it makes it difficult to add an additional burden for folks. However, I'd just like to clarify, we're talking about like $2. If you have a $70,000 salary, you're paying in the range of $2 to $5 a paycheck if it is a universal program, which is what I think could be accessible for everyone.
All right.
Mr. Chairman, could I ask a question?
Senator Bell.
Clarification, you said 0.5%. I don't want to put you on the public math, but are we meaning 5% or 50%?
No. One moment. Let me find exactly that, Mr. Bell. I think it's 0.05, but let me just make sure.
Okay, because that's going to make a huge difference. My heart skipped a beat when you said that. Mr. Chairman, if I could ask another question. If a business, according to what Senator Newman said, already has a plan, would they be required to do this plan on top of the other plan, or just if they have a plan that would suffice, that would be it?
Mr. Chairman, I would respond. I've spoken to some people who work for the very large businesses in Virginia who have existing plans right now. This would actually be less expensive for them because it would be, again, the cost per person would be lower. And I will ask my witness to clarify the percentage amount because I am unfortunately.
Okay, you ready for us to have public testimony?
Mr. Chair, I'd just like to ask a question.
Senator Deeds.
Yeah, we just passed Senate Bill 1219. I wonder if staff or someone could advise me whether this bill would be totally inconsistent with that approach. I mean, if we ask the State Corporation Commission to develop a plan and then we develop our own complex plan, how is that consistent?
Well, this directs the Virginia Employment Commission.
But this is a complex, what I'm saying, that's a study that asks the State Corporation Commission to develop a plan. This is a pretty complex plan right now. So it's
Mr. Chairman, would you like me to respond? So, thank you, Mr. Chairman, Senator Deeds. We feel that because there is not a private provider option in Virginia at this point, the two are collaborative. The two initiatives are collaborative. We do not have a set, forced way of doing this. I want this to be done in the way that works for Virginia. And if having a private option, think of this as the Affordable Care Act. I'm looking for universal coverage, and I want to make sure that everybody has access to it. If we end up having a private provider option, I can live with that. So I I want us to think of this as a process for moving towards universal coverage. We did a big study last year, and with the Secretary of Commerce and Workforce Development, they said that that could be a possibility. So they're not inconsistent with one another.
Mr. Chair, well, Senator Boysko, is this bill a product of that study?
Yes, it is. It's a direct one.
All right, we're ready for testimony now. We've spent enough time on this part. First, we'll hear from the proponents, and then the opponents, each side, 3 minutes. All right, first up for the proponents, those supporting the bill.
Jody Roth, please go ahead.
Is supporting the bill.
Yeah, Mr. Chairman, I do not support the bill. I'm happy to wait.
You support the bill or you don't?
He does not. I do not.
You do not. Well, I want to hear first from those supporting the bill.
Correct. Correct.
Okay.
Mr. Chairman, I know that Vicky Szabo is waiting in line to speak.
Who is?
Vicky Szabo.
All right.
Good morning.
Ms.
Good
Szabo?
morning. Good afternoon. I am here as an expert to help. So I am strongly in favor of the bill, and I'm happy to answer questions, including those about the payroll tax rate. I believe the bill specifies that it is 0.5. It's 0.5%, and that's very consistent with the other states that have passed bills like this before. And happy to talk through questions about the funding mechanism. To just answer the question, I think if a voluntary option were put in, you could easily see how the bill that passed previously and this bill could work together to figure out a viable way to create a universal program that has some private pathways for employers that meet certain standards.
All right, thank you. Next.
Hi.
Christina Hagan.
Good afternoon, Mr. Chair, members of the committee. My name is Christina Hagan, and I serve as director of the... Ooh, can you hear me?
Yes.
Excellent. Hello, sir. How are you?
Fine. How you doing?
Doing well. Doing well. So I serve as director of the Virginia Campaign for a Family-Friendly Economy. Our organization advocates for policies that lift up Virginia families while strengthening our economy. Paid family medical leave is a primary way we can ensure hardworking families don't have to make an impossible choice between their own and their family's health and bringing home a paycheck, especially now in the midst of a pandemic. Last year's working group study, which was overseen by Secretary Brian Ball and Dr. Megan Healy, and which underpins, frankly, this bill, demonstrates that paid leave is both attainable and affordable for our workers, for our employers, and for our Commonwealth. As our economy continues to reopen, paid leave is also critical to mitigate the spread of coronavirus and ensure a healthy, financially stable workforce. Many smaller employers are finding themselves wanting to provide paid leave, but unable to shoulder the expense in the absence of such a program, and that's what we're trying to change. So thank you for your time and your consideration today.
Okay, thank you. Next.
Dominique Martin, please go ahead.
Good afternoon, Mr. Chair, members of the committee. My name is Dominique Martin, Policy Research Analyst, New Virginia Majority. I'd like to echo the sentiments of previous speakers and also just say that paid family medical leave is an economic justice issue and a matter of public health consideration. And so we urge you to support the bill. Thank you.
Thank you. Next, speaking in favor.
Dana Wiggins.
Who?
Good afternoon,
Oh,
Mr.
Dana
Chairman.
Okay. Welcome,
Good
Dana.
afternoon, Mr. Chairman, members of the committee. Dana Wiggins with the Virginia Poverty Law Center. We are in support of this measure, and we just think it will echo previous comments and support, but we just think that it's an important step to protect families moving forward, particularly after what everyone has been through these days. So we are in support. Thank you so much.
All right, time is up. Now we will be hearing from those who oppose the bill. First up, is Jody Rouse still there?
Yes. Good afternoon, Mr. Chairman. Jody Roth on behalf of Virginia Retail Federation, and we stand in opposition to this bill, given the cost that it is going to be putting on business owners, as it is a payroll tax. In addition to, many business owners will also be having to backfill that position, especially in the retail environment, and pay for another employee to cover those days. And now is just not the time, while most businesses are struggling to just stay afloat and get their feet back under them. therefore, we do stand in opposition. Thank you for your time to speak.
Okay. Next, those in opposed to the bill.
Nicole Riley.
Good afternoon, Mr. Chairman.
Welcome, Ms. Riley.
Hello, sir. Just very briefly, I associate myself with the comments made from Jody Roth. I think it really is important that it gets lost in the equation, is that that small business owner has to replace that worker, at least temporarily. And that is additional cost and burden for a small business, particularly if they have a very small workforce. And also just wanted to say, we certainly supported Senator Favola's bill because we do think that there is the opportunity in the private market to provide, hopefully, affordable products for employers to be able to provide this, and would prefer that over a state plan. Thank you.
Next, in opposition.
Jonathan Iglesias.
Jonathan Iglesias, we're actually for the bill. Do you want us to speak?
No, you missed your opportunity.
Okay. All right,
Next,
gotcha.
in opposition to the bill.
Eric Rison.
Good afternoon, Mr. Chairman, and thank you, Senator Boysko. I'm Eric Rison, Director of Public Policy for the Virginia Chamber of Commerce. On behalf of our 27,000 member companies in Virginia, we have just a few concerns with the proposal. It adds a new substantial mandate on employers during a time when we should be looking to lessen some of those burdens on employers, especially small business. It removes some of the flexibility that employers have in providing a variety of leave benefits already, and it adds a new substantial responsibility for the already overextended Virginia Employment Commission. And then lastly, the indeterminate fiscal cost, which, it's pass this bill and then find out how much it's going to cost later on. We have concerns with that approach. So for those reasons, we're unable to support, but appreciate the intent of the patron.
Okay. 20 seconds left. One more speaker in opposition.
Terry Durkin.
Thank you, Mr. Chairman. Terry Durkin, representing the Roanoke Regional Chamber in Virginia West. For the reasons previously stated, we oppose this bill. Thank you.
Okay. All right. Time's up. Bill's back here. If there's no further, Senator Newman.
Mr. Chairman, as I'm reading, just to make sure, if you're currently providing paid family leave, you're still going to get taxed to pay for it again, right?
Thank you, Mr. Chairman and Senator Newman. I think that you would have the ability to let go of the program. And let me just
say, Mr. Chairman.
As it's written now.
Mr. Chairman, I think you would have to pay twice. Number two, for instance, my company has a union negotiated. We can't just get rid of it, right? It's a 3-year deal, and either one will take over. I think we'll have to pay twice.
Mr. Chairman, I believe that if this would supersede that program, so you would be able to eliminate the other, that would be the idea of it. However, I don't have documentation of that, and I appreciate the gentleman's question.
Mr. Chairman. Mr. Chairman.
Over here.
Over here. Nick.
Norman.
Mr. Chairman. I have a motion, sir.
All right.
I would respectfully move to pass the bill by indefinitely.
Is there a second? You've heard the motion to pass the bill by indefinitely. All those in favor of passing it by indefinitely vote yea. Those opposed vote no.
Ayes 12, noes 3.
Okay.
Thank you. I have a second bill. Would you like
Your
me
next bill, let's see. Okay, the next bill is 1228, Senator Boysko, Virginia Equal Pay Act, civil penalties. Tell us what the bill does and why we need it.
Mr. Chairman and members of the committee, 1228 updates the would you like me to wait till everybody's ready?
Okay, go ahead.
It updates Virginia's 1974 Equal Pay Act. Existing law already requires that employers pay their employees equal pay for equal work, and it already allows lawsuits under this statute. The legislation that I'm asking you for today is crafted carefully to narrow the existing wage gap between the pay of women and minorities and white men, to put it bluntly. Legislation like this is going to close loopholes and strengthen enforcement of equal pay laws. And this kind of legislation has passed in 19 other states, including my home state of Alabama and another conservative state of Nebraska. This wage bill is an economic justice bill. The wage gap, we know, is greater for women of color. Black women earn 62 cents, and Latinas 53 cents for every dollar of a white man, and the wage gap persists regardless of industry, regardless of education level.
Don't we already have a federal law?
We have a federal law, but there are not any teeth in it, and that's what I'm trying to propose today with just 2 or 3 simple things that can change that and have shown to make a difference in helping parity. Last year, Delegate Chris Hurst had a bill that resulted in a study, and I can see the writing on the wall that mandates are going to come down where people have to report everything. This is not that bill. This is simply saying, 1, allow workers to share their salary information, which he had in his bill last year. Secondly, offer job promotions and opportunities and career opportunities to all employees. Avoid the pitfall of targeting only certain employees for advancement based on something other than their qualifications. Third, set a wage salary when posting job. When a prior history is used, and I'm going to use myself as an example, because this is my job, I make $18,000 a year. If I were going to go on monster.com or one of the other job searches, and I put my salary in for a job that I'm well qualified for, I'd get kicked out of it immediately because I only make $18,000 a year. This bill would help us eliminate that kind of thing. There are plenty of people who have taken time away from work, who have done public sector jobs, who have lost their jobs because of the pandemic or others that we're seeing right now, who, when they're going out and looking for work, are going to be penalized because their salary, their wage was not what they're asking for in this, in the level that they are qualified for. This is we have passed this kind of law. I will just say it again, in Alabama, guys. I mean, I pride myself on living in Virginia now because Virginia is ahead of the curve on employment issues. This really, I'm going to go back to it again. People have worked for lower wages while finishing school, for caring for their family. Imagine your wife going back to work, or your husband after taking care of the kids when they were young, for nonprofits and government jobs. They're paid less for the old jobs that they had. This would help them compete on an even playing field. I've been working with the American Association for University Women and the National Women's Law Center on the language of the bill. They have worked around the country to pass this kind of legislation, and I hope that you will give it a fair chance. I know that I carried this bill last year, and it didn't actually get fully considered. I've carried it a few times. I hope you will give this a fair chance, because I think it's important, and I'm not asking for broad, crazy mandates here. I'm asking for some safeguards that will help companies understand what they need to do in order to meet the federal standards and the state standards. And I will let our witnesses speak now. Thank you, or take your questions.
You've heard this. Questions from the committee? All right, we move into the hearing part, public. Those who are in favor of it first, please raise your hands. Those who are in favor. All right, you will speak first, and you have a total of, between all of you, grand total of 3 minutes. Okay? All right, first up is who?
Dominique Martin.
Good afternoon again, Mr. Chair and members of the committee. Dominic Martin, Policy Research Analyst, New Virginia Majority. We're also in support of this bill because it advances racial and economic justice for Virginians and gets us closer to a truly just and equitable Virginia, and hope you will support the bill as well. Thank you.
Andrea Johnson.
Good afternoon, Mr. Chairman. My name is Andrea Johnson. I'm a Director of State Policy at the National Women's Law Center. And Virginia has had an equal pay law on the books for over 45 years, but loopholes and inadequacies have arisen that have really made it grossly inadequate at stopping pay discrimination. And in my work across the country with states, state legislators, state advocates, I see that this bill here in Virginia includes the same basic common sense steps as laid out in the legislation in many of the 19 states that Senator Boysko referenced. They've strengthened their equal pay laws and sought to close loopholes in very similar ways to this bill in just the last 5 years. What is really exciting about this bill is the proactive measures it includes that will help insulate Virginia businesses against wage gaps and equal pay lawsuits. This bill is really structured to provide employers practical tools to prevent lawsuits. So for example, by ending reliance on salary history to set pay and requiring salary range transparency, the bill helps ensure employers aren't inadvertently introducing wage gaps into their workplace and helps them decrease their exposure to lawsuits. We've seen those similar salary history measures pass in 14 states, all with bipartisan support. And although these laws are relatively new, what's really impressive is that this research is already showing that they are helping close wage gaps in the states that they have passed. And we're seeing a growing number of businesses announce that they will no longer rely on salary history and come out in support of this type of legislation. And really, as businesses are seeking to rebuild from COVID, salary range transparency will not only help avoid wage gaps that arise during the hiring process and negotiation when we aren't transparent about salary ranges, but it will help businesses more efficiently and effectively match with interested candidates.
You have less than a minute
job
now.
seekers enter the workforce. Thank you.
All right. Is there any other speakers in support of the bill?
There are no other hands raised, Mr. Chairman.
Okay. All right. We move now to the opposition. Those who are opposed to the bill, raise your hand for just a second. All right. Okay, who's up first?
Nicole Riley.
Okay, Ms. Riley, welcome.
Good afternoon, Senator and members of the committee. We definitely have some concerns with this bill on behalf of our small business members with NFIB. And one of them is that it does seem to create a complicated set of criteria to prove why you did have wage differential between your employees when trying to prove that it's appropriate. Also, it does create 3 years of paperwork that you need to maintain on a number of things from job descriptions, salaries, and for small business owners, like a lot of my members are less than 20 employees. They don't have a human resources department or director who handles all of this. This is all kept in a file cabinet that the employer looks at, when he's watching Law and Order reruns from his kitchen table, dealing with, other pieces of his business. So we just feel like this really does create some hardship on business owners, especially too when you talk about prohibiting them asking for salary history. Small business owners don't have access to like market studies of what is the going rate. So for many of them, they ask that because they want to make sure that they're not lowballing any good potential employees. So again, with those concerns, we would oppose the bill. Thank you.
Okay. All right. Next up in opposition.
Robert Melvin.
Mr. Chairman, members of the committee, Robert Melvin with the Virginia Restaurant Lodging and Travel Association. We would like to echo the remarks that were made by Ms. Riley for some of the concerns that we have with this measure, and would urge you to oppose it. Thank you very much.
Jody Roth, please go ahead.
All right, next.
Good afternoon, Mr. Chairman. Jody Roth on behalf
Welcome.
of Virginia Retail Federation. Thank you for taking the time to hear from us. And we just want to echo the comments of Ms. Riley as well. And we stand in opposition to this bill for all the reasons she just mentioned. Thank you.
Okay. Any other speakers?
There are no more speakers, Mr. Chairman.
That's it. All right, it's back and it's before us. I have a question to ask. Doesn't federal law cover this?
Mr. Chairman, there is a federal law, there is a state law. However, we still, and we just did a study on this last year, there continues to be a significant wage gap. This would help companies know what they need to do to fix it.
Mr. Chairman. Well, if there's a
Mr.
federal
Chairman.
law, why isn't action being brought under that?
I'm amending it. There are many laws that we amend.
We can't amend a
Need
federal law.
changes. No, we're doing the Virginia Equal Pay Act of
All right.
1974.
Mr.
here.
Chairman, Surville.
Senator Surville.
Thank you, Mr. Chairman. Speaking of the bill, Mr. Chairman, I think the point, I don't mean to speak for Senator Boysko, if she can speak to her own bill, but I think under the federal law and the existing state statute, which this repeals, it has just a very sort of vague, broad, open-ended directive that employers not discriminate on the basis of sex. And it's not very specific. And there's been litigation out there about whether certain practices or not might cause discrimination in a specific place of employment. But I believe what this bill is based on is there's been certain studies that have been done which have identified there are certain practices that many employers engage in which tend to have a disparate impact on women or minorities or other people across the board. For example, asking for somebody's salary history as part of their application has been shown to suppress wages amongst certain groups of people. And so I believe the idea behind this bill is that we need to be more prescriptive about certain practices to get the law to hurry up a little bit. And I would just say, Mr. Chairman, as a business owner, I can tell you that in my experience, there's a lot of people that are much harder negotiators of their terms of their compensation than others. And I believe that these studies tend to show there are gender trends and that, for example, women don't tend to assert themselves nearly as aggressively in salary negotiations as men do, and that in general results in women overall getting paid less. And in states where they've done these kinds of things, it tends to close the gap. I think that's the idea. And so those parts of the bill, I think, have been sort of independently validated and have some merit. This bill, though, is really big, and it has a lot of stuff in it that I'm not, as an attorney, I mean, it'd be great to have, or at least if I'm on the plaintiff's side. I worry a little bit about some pieces of it, and I just wish we had somewhere we could send things like this to be vetted and chewed on in a broader context by, in more than like 6 minutes of testimony from either side, because I think there's some merits to pieces of this that I think we ought to look at. But it's a pretty broad bill, I'll give you that.
Mr. Chairman, I have a question. Right here, over here, Edwards. Yeah, Senator. Senator, I have a question. It looks to me like there's no limitation on the number of employees an employer can have. It talks about one or more employees or individuals. Is that right? No limitation at all?
Mr. Chairman, there's no limitation. This would apply to everybody. And I just would like to also point out that these provisions are what have passed in other states, and they have been successful.
Senator Newman and then Senator Marsden.
Mr. Chairman, I just hope we'll slow down and look at lines 100 through lines 130. This right of action, Senator Surville is exactly right. What a lawyer bill. Get this. It's the difference between the wages paid and the maximum wages paid. Then there's liquidated damages. And then there's compulsory damages or $10,000, whichever's higher. Then, on top of that, there's punitive damages on top of that. And then there's reasonable attorney's fees. And there's legal and equitable relief that comes in. And you can have a group of employees. This section is certainly a lawyer's dream, but right now, with businesses where they are, this would be, I think, a knockout punch. I mean, this is a massive recovery section.
Mr. Moore.
Thank you, Mr. Chairman. Question for the patron. Senator Boysko, this may seem a little far-fetched, but could someone come into compliance with this law by reducing salaries of their employees, and maybe raising a few and reducing others? Would it preclude people or allow employers to reduce salaries to come into compliance?
Mr. Chairman, Senator Marsden, I think you're missing the point, is that businesses set their budgets, and they use their budgets to set what wages they're going to pay for people. That's where we should be letting them focus, as opposed to looking at somebody's salary history.
Mr. Chairman, if I could just follow up. In other words, could they sort of redo their whole salary structure to get into compliance, and reducing the salaries of some and raising the salaries of others? Would that be a reasonable way for an organization to approach coming into compliance with this law?
Mr. Chairman, my bill simply says you make sure that everybody knows what the job opportunities are. You let your employees talk about their salaries amongst themselves. And when you're coming in for an initial job interview, you don't ask the salary history. You can have the salary history conversation later on when you have brought, when you're in negotiations, but you don't use that one to kick somebody out of the running for the job. And you don't use that as an excuse to pay them lower than what you know the job is worthy of. Just like here in this body, we all know that we get the same salary. We all know that we're expected to do the same work that we're qualified for. That's the intent and the focus of this bill. And businesses have their budgets set. They know how much a clerk is. They know how much a babysitter is. They know how much an administrative assistant is. They know these things already. I'm not asking for brain surgery here.
Mr. Chairman.
Thank you, Mr. Chairman.
Senator Norman.
Picking up on one of the last points, we may all get paid the same, but God did not make every legislator the same. This kind of reminds me of a good Bordeaux grape that has just been picked but has not had the opportunity to mature in the cask before it's bottled. And I think that it would be appropriate for us to allow this legislation to mature a little bit, and hopefully it will condense itself down to not be so broad-based with so many aspects to it. And Mr. Chairman, I would move to pass the bill by indefinitely.
Mr. Chairman. Surville.
There's a motion. Is there a second? All right, there's a motion and a second. Senator Surville.
Mr. Chairman, I would be curious if the senator would see it as a friendly amendment to ask that the chairman also write a letter to the Virginia Employment Commission asking them to assemble a work group of stakeholders to vet this legislation to see if there's a good Virginia way to achieve these policies that have been done in other states.
Mr. Chairman, I would consider that friendly because, like a lot of pieces of legislation, we see the patrons line up those who are advocates and fierce advocates for the legislation, and it is not always examined in an objective way. And I'm very comfortable with what Senator Surville has proposed.
That I would send a letter to
Virginia Employment Commission.
VEC, asking them to assemble. Okay, if you just text me exactly what you want.
I'll work with Senator Boysko on some text.
All right, you all have heard the motion. There's
Mr. Chairman. Mr. Chairman, I support this approach. I mean, I think that my good friend, the patrons, bill is going in the right direction, but I craft this letter, we try to narrow this down. For instance, there's areas where we say the wage range, but if one position only has one wage, there isn't a range. So what do you do in that case? Because there's no out here that I can see.
Mr.
And there's a few other things that I would ask if we could do it. I'd be happy to help work with on that. I will also say that often you mentioned the story with the clerk. I've seen in different businesses I've been a part of where we've bid on work, and to win the work, if it's particularly goes to the low bid winner, you may not be able to pay the same on every job because you had to bid it lower. So you typically need to hire somebody with less experience, certifications, et cetera, in order to be cost competitive. So it can be fairly complicated. I would be worried about some businesses, particularly small ones, getting sued because they're trying to do navigate some of these things, because it could be fairly complicated.
Mr. Chairman?
Senator Surville and Senator Boysko work on a letter, and I will send it to the chairman of
Thank you.
VEC.
Thank you.
All right, there's a motion now.
May I make a couple of comments before we end, just to clarify that I'm not way out. We're talking, if there's a bona fide seniority system, that would be of course. If there's only one wage that you're paying everybody, that's exactly fine. It is illegal to reduce somebody else's salary for the reasons that Senator Marsden brought up. Once again, this has passed. The reason that it is legalese is because there's complexity. We want to make sure that we're covering all of the bases here. But the three components are simple.
Mr. Chairman, there's a motion on the floor.
Thank you.
Yes, there is. All right, you've heard the motion that the bill be passed by indefinitely with the chairman sending a letter to the chairman of VEC asking them to put together a study group to see if they can't come up with something that's doable.
Thank you, Mr.
All right.
Chairman. Members of the committee.
That's the motion. If you're in favor of that, vote aye. If you're opposed, vote no. All right.
Ayes 15, no 0.
Ayes 15, no 0. All right.
Thank you.
We have one bill left, and I don't know if she's here. Senator Hashmi. She's here. Okay. This is it. Welcome, Senator Hashmi. Your bill is 1358, Employment Health and Safety Standards dealing with heat illness prevention. Tell them why we need to explain the bill and why we need it.
Thank you very much, Mr. Chair, and thank you to the members of the committee. SB 1358 is regarding the problem of heat stress that often affects many workers in our Commonwealth. And it's an interesting fact that actually the largest primary weather-related cause of death in the United States is resultant of heat stress. So it's not from terrible environmental catastrophes such as floods or hurricanes. Heat is the primary weather-related cause of death. And at present, we have no real protections in place for our workers, whether they're working outdoors or indoors. And so this bill in particular offers an opportunity for us to make sure that we are providing standards and guidelines. And I should have started. I'm sorry, I believe there's a substitute that was made available. Is that correct?
Mr. Chair,
Have you received the substitute?
I don't have a substitute for this bill.
I can make the substitute available now.
Mr. Chairman, all right, so we should, I've not seen the substitute, but.
It should be coming to your LIS.
Okay.
The draft of it should shortly.
All right, is there a motion to adopt the substitute?
So moved.
All right, motion and a second. All those in favor, say aye. Opposed? All right, substitute is before us.
Thank you, Mr. Chair. So this particular bill is asking that our Safety and Health Codes Board adopt regulations to establish standards, and mainly these are standards to provide shade, to provide water, and to provide breaks in a responsive manner so that our farm workers, our construction workers, those who work in intense heat environments such as bakeries, have the opportunity to get relief as necessary in order to protect themselves from sickness and from possible fatality. And I believe we have a few folks who are lined up to speak in favor of the bill if the committee wishes to hear them.
Okay. Are there any questions of the patron before we go to
Mr. Chairman,
Senator Mason?
Senator Hashmi, what are the different, the substitute hadn't popped up. What did the substitute do and what are the changes, and can you walk us through that?
Yes, thank you, Senator Mason. So in section F, the substitute is correcting, making a line adjustment, a technical adjustment, where it reads, in addition to any penalties provided by this title and without regard to any exhaustion of alternative administrative remedies provided for in this title, an employee may bring in an appropriate court of the Commonwealth an action based on a violation of this section here under lowercase 1, enjoin a violation, 2, recover actual monetary loss, and 3, both actions in cause 1 and 2. It is a change that allows for there to be both actions taken rather than either or.
Mr. Chair? Right here.
Senator Barker.
Yes, question, Senator Hashmi. Are there OSHA standards that relate to heat issues, and is this basically doing a state imposition on people who would not be covered under the OSHA standards, or is this going in a different direction?
I believe there are recommendations made by OSHA on these standards, but they're not implemented necessarily as protections across the states.
Senator Mason.
So, thank you, Mr. Chairman. So, Senator Hashmi, you know, at the shipyard today, it is freezing cold out there. But in the foundry, which is one of my favorite parts of the shipyard, if they're pouring today, it's hot today. So the foundry in June, July, and August is unbelievably hot, as is the rest of the shipyard. Certainly, they have to be governed by some standard today to keep the workers safe. And how would your bill impact that particular industry?
I didn't catch the last part of your sentence.
Just saying, ma'am, you were talking about OSHA, so certainly they're governed by some requirement to protect the worker today. So how does your bill differ, and how would it impact those workers in the shipyard that it's guaranteed, particularly in the foundry, but anywhere in the shipyard, June, July, and August, it is 100 degrees plus in that work environment?
So what we're asking our Safety and Health Codes Board is to adopt the regulations that establish the standards. And this was an issue that we had looked at last year during the 2020 session. And in that context, we actually defined the standards, asked that they be implemented uniformly across all industries. And at this point now, we're asking in this particular bill that the Safety and Health Codes Board actually adopt standards and make sure that those are implemented rather than do it through our legislative means.
Senator Obenshain.
And building on Senator Mason's question, I mean, it would seem to me that if there are federal standards already, this bill would do one of three things. It would either require Virginia to adopt standards that are more strict than the federal standards, the same as the federal standards, or less stringent than the federal standards. If it's the second and third, I don't understand what the purpose is for the bill. If it is to adopt standards that are more strict, I think Senator Mason's question raises concerns and questions for me about how exactly is that going to impact businesses and agricultural enterprises in Virginia? How much more strict would it be?
If it's possible to bring in our outside speakers, we have attorneys from Legal Aid Justice Center who would be able to address that concern.
Mr. Chairman?
Senator Bell.
Mr. Chairman, in in my company, we have people working in heat environments all the time, so we deal with this. And I can tell you, I'm reading right now from the OSHA website, and to that question, OSHA does not have a specific standards that covers working in hot environments. Nevertheless, OSHA acts dictates that employers have a duty to protect workers from recognized serious hazards in the workplace, including heat-related hazards. So it sounds like this would add something we don't have in OSHA.
We have recommendations, but not clear standards.
All right, anyone else?
Mr. Chairman?
Senator Lewis.
Just a question for Senator Hashmi. I heard you in your opening remarks mention, I think it was a national statistic. Do we have any kind of sense of if heat exhaustion or heat exposure is a significant problem in Virginia, or are we just going on some national trend, or what is that?
We do have some data. Thank you, Senator, for the question. We do have some data in Virginia, and I believe in 2019 we had approximately 1,000 deaths in Virginia. I may be incorrect. I'm trying to find that data again, but I know we had, I think it was about 1,000 deaths in Virginia related to heat illness, heat stroke, and any of the health issues that arise from extreme heat. Most of these are workplace related. A few of them were sadly in conjunction with infants and young children left in cars and vehicles. But most of them were workplace related. And they primarily affect men who work in outdoor capacities, whether they're on the farm or in factories. And so it's typically middle-aged and older men are the primary victims of heat stress.
Mr. Chairman?
Senator Evans.
Just want to point out the substitutes online now, and it seems pretty reasonable to me that the standards that are adopted could include things like provision of drinking water, access to shade or climate-controlled environments, rest periods, effective emergency response procedures, acclimatization to working in heat, et cetera. So it seems pretty reasonable to me that we would cover this.
All right. Bills before, have we heard from people?
Not yet.
No, we haven't done that yet.
Come on, Dick.
He wasn't. I don't think he even understood it. All right. Those who are in favor of the bill, please raise your hand, and we'll get you in line. Each side has 3 minutes. Senator Hashmi, first, before we do, did you want to say something?
I was just hoping that we might start with Jason from LAJC.
With who?
Jason.
All right, is Jason there?
Hi, yes, this is Jason Urashis, Legal Aid Justice Center. Thank you, Mr. Chairman and members of the committee. I will briefly note before I cede my time to my colleagues, just as a response, that the federal standards are merely recommendations. There is no comprehensive heat illness regulation. Actually, 2 times in the last decade, there has been petitions by public citizen and others to do so. Back in 2011, it was explicitly denied, and there has not, to my knowledge, been a specific response to the 2018 petition. So knowing that, I'm happy to answer other questions, but I'll cede the rest of my time to my colleagues.
Okay. Thank you. Next on the pro side.
Robert Bohannon.
I'm actually on the con side, so happy to go when that's up.
Bob Kitchen, please go ahead.
Yeah, hi. Thank you for allowing me to testify today. And I'm Bob Kitchen, Fairfax Station, a family practice physician and a member of Virginia Clinicians for Climate Action, and we do support this legislation. And As a primary care physician, I recognize the importance of prevention and preventing my patients from becoming ill. And this legislation provides a number of preventive measures to help protect our workers. And we'd had a question earlier about what's the impact in Virginia. And I'll just share with you that OSHA keeps track of worker deaths. And I'll just highlight two that they reported for Virginia. One was in the shipbuilding area in Norfolk. A worker was performing cleanup operations on the ship deck and collapsed, and NOAA said the heat index was 97 degrees. He died. And in Nathalie, Virginia, an employee was working in a tobacco field pruning tobacco by hand. He collapsed and he died en route to the hospital. So there is an impact on Virginia workers, and we want to do what we can to protect them from this ever-expanding health risk. So we support Senate Bill 1358. Thank you.
Michelle Barreto.
Mr. Chairman, members of the committee, my name is Tanya Osenkoski. I'm reading the testimony by Misael Barreto. Good afternoon, honorable legislators. My name is Misael Barreto, and I work in the tomato harvest in Virginia. My experience was good, but with difficult moments, since working in tomato means working in high temperatures up to 110 degrees Fahrenheit. We have to work very fast and under a lot of pressure. The heat is oppressive and exhausting. There were coworkers of mine who fainted in the heat. In one occasion, I got dizzy. I had to go to the shade and drink water to recuperate. Furthermore, the pesticides mix with the sweat on your skin, forehead, and neck. I want the work conditions to improve through better regulation.
Beckham Stanley.
I am on the opposition side, but I'm happy to go if the committee would allow it.
Sky Wheeler, please go ahead.
Hi, my name is Sky Wheeler. Thank you very much for this opportunity. I work for Human Rights Watch, an international human rights organization, and we support these common sense provisions for safe and dignified work as protected under international human rights law. It's also worth noting that pregnant people are especially sensitive to heat. We have a maternal health crisis in this country, and we also have a premature birth crisis. And emerging evidence is showing that exposure to high temperatures contributes to premature birth. So there are many reasons to support these kinds of state legislation. Thank you very much.
Okay, now we're going to hear from the opposition. Wave your hand and we'll move you up into the pictures. All right?
Robert Bohannon.
Hi, Mr. Chairman. Rob Bohannon, representing the Virginia Transportation Construction Alliance and the Richmond Area Municipal Contractors Association. As you might imagine, we understand what Senator Hashmi is getting at. Protecting workers is a good thing. We represent the road construction and heavy construction industries. As you might imagine, work oftentimes in very hot locations. Safety is at the forefront of everything we do. So it's part of the safety protocols to protect workers when they're on the job site. The last thing that we want to see is a worker get sick from heat illness. I will point out that the OSHA Act of 1970 requires employers to provide a place of employment that's free from recognized hazards, which also includes heat-related hazards. Only 2 states go on their own sort of regulations, and that's really because the federal standards are what most states look at with regards to protecting workers. So for those reasons, we oppose the bill.
Beckham Stanley.
Thank you, Mr. Chairman. Beck Stanley for the Virginia Agribusiness Council. I haven't seen the substitute, but last year we opposed this and we agreed to work through a regulatory process, and we would just ask to have that chance and table this until that happens.
Paul Davis.
My name is Paul Davis. I represent the Virginia Association of Roofing Professionals as an executive board member and also a member contractor. We oppose this bill as is already VOSH and OSHA already maintain regulatory control. Workplace safety in general is paramount in our industry, especially with regards to heat illness, and something that as contractors we've been dealing with this issue, a number of years. We have provisions in place to protect our workers when necessary, and we know how to navigate this this issue of working in the heat. The state already provides various avenues in the form of recourse to protect workers. We just feel that this legislation is overly burdensome on employers in general, and we just feel that it's just unnecessary at this time.
Philip Abraham, please go ahead.
Thank you, Mr.
Next.
Chairman, members of the committee. Phil Abraham, representing the Old Dominion Highway Contractors. We oppose this legislation not because we're against protecting our workers from heat illness, but because of the breadth of this proposed legislation. It applies to all forms of employment, both indoor and outdoor. And we prefer that there be a stakeholder group to work through this issue, see what categories of employment should be covered, and more specificity as to what standards might be applied. According to OSHA, only 3 states right now have heat standards in effect. Those are California, Minnesota, and Washington. And only California has them apply to both indoor and outdoor work, where this legislation would also apply to indoor and outdoor work. Thank you very much.
Mr. Chair.
Time is up.
Mr. Chair.
Senator Dees.
Senator Hashmi, I think one of the speakers spoke about a regulatory group he was supposed to work with since last year. I wonder, was there any sort of group that did any work on this idea over the course of the past, since last regular session?
Thank you, thank you, Senator. It was referred to the administration, to the Safety and Health Codes Board to take a look at, and the determination, I think, was not fully made as to what kind of guidelines and regulations should be articulated for the state, and that's why the bill is asking for a more comprehensive articulation.
Mr. Chair, they met and didn't make a good recommendation, or one you didn't like, or they didn't make a complete recommendation, or they didn't meet?
I believe they met but made no recommendations. Okay. That's my understanding.
Mr. Chairman.
Senator Barker.
Yeah, just to follow up on that, Senator Hashmi, did just the board meet, or did they have stakeholders? Was it a stakeholder group that was meeting?
The stakeholders were part of that conversation, is my understanding.
Okay.
Mr. Chairman.
Mr. Chair, just to follow up, I mean, my interpretation of what a couple of the people who were spoke in opposition to the bill implied that they did not have a stakeholder group meeting. So it would be helpful to have that clarified, so.
Okay, thank you. It was my understanding that the stakeholders, along with workers, advocacy groups, were part of that conversation, but that the recommendations were not determined. But I may be wrong if the gentleman who spoke earlier said that they were not part of the conversation.
Madam, or Mr. Chair, Senator Hashmi, you weren't part of any of those discussions, though, is that correct?
I was not part of the discussion.
Well, if Beck Stanley's still there, still online, he's the one that spoke about regulatory discussion.
Yes, Senator Deeds, Beck Stanley for the Virginia Agribusiness Council. We were not able to have those discussions due to the pandemic, and we were just asked to go through that regulatory process. Okay. And table this until we can do that.
Okay, and I just got a text from somebody that said they didn't meet. Mr. Chair, I would suggest we do with this bill, we deal with this bill in a similar fashion as Senator Boysko's bill, that we pass the bill by and you write a letter to that group or the employment commissioner or somebody and order them to convene a work group of the various interest groups to figure out what makes sense.
Mr. Chairman.
First Senator Sproul and then Senator Serville.
That's my problem. We keep passing stuff by, and for letter. My question that I want to make sure that we would get what the senator needs. This is about our third one that we keep passing stuff by, and I don't have the assurance that we can get it through. To me, I'd rather pass the bill out and then send a letter. That would be a cover both ways, just in case the letter doesn't work. So what's wrong with that?
Mr. Chairman. Mr. Chairman.
Mr.
Chairman.
Senator Larson, then Senator Newman.
Thank you, Mr. Chairman. What happened to me?
I'm sorry.
Same thing that always happens to you.
So shine, retire.
Thank you, Mr. Chairman. My question, or I guess I was just going to suggest that I think the VEC probably has more to do with wages and hours, whereas the Department of Labor and Industry might have more to do with working conditions, but they might be in a more appropriate place for it to be looked at rather than the VEC. That's speculation by me. There might be somebody else here smarter than that, but.
Mr. Chairman, if I may, I received clarifying text. So apparently the regulatory process has happened. It's been sitting on the Secretary's desk for almost 300 days since the last session, but the unanimous decision by the board was to regulate and provide this heat safety bill.
Mr. Chair.
That's my case.
Mr. Chair, and at the same time, I'm receiving text from the wineries industry suggesting that they didn't meet because of COVID, or at least they didn't convene the stakeholders.
Did they meet or they didn't meet?
The information that I've received is that the regulatory process has happened and is sitting on the Secretary's desk since last session.
So in other words, they have met. Well, there's no sense sending a letter if they've already met.
But I'm receiving information that they didn't meet. The stakeholders did not.
All right, why don't we take this by for the day and find out what the exact status of it is?
Mr. Chairman.
Okay, just for
Mr.
the
Chairman.
day. Senator Spruill.
Mr. Chairman, excuse me. We keep doing this. My point is this. Why not get this thing out of here and then check and make sure? Because we won't have to come back if we pass and get it out and then check on stakeholders. Because if you got a letter that's sitting up on the desk for a whole year, we're just wasting time. My concern was why not get it, pass the bill out, and then check to see what it is.
You know, you can make motions whenever you all want, and I hope it's sooner than later.
Mr. Chairman, just
Hold on. Senator
a
Marsden.
quick question. Could, you know, they have rules around, for instance, high school football and heat, where, you know, referees will sit there, check the temperature, swing this measurement for humidity, and they'll decide whether you can play or not. Could these regulations lead to not just remediation of heat conditions and what have you, but saying that on a day that certain standards are met, you can't work? Would that be a potential thing that we need to take into consideration here as to whether a regulation could go that far?
Mr. Chairman and Senator, as I read the bill, it is regulations for shade, for supply of water, and for adequate breaks in between in order to recover, and that is what the regulations focus on.
All right, we need a motion one way or another.
I move report.
All right, there's a motion to report. Is there a second? Second. All right, a motion and a second to report. Discussion.
Substitute motion, Mr.
All right.
Chair.
Huh?
Substitute motion.
All right, substitute motion.
I move that we pass it by for the day so that we can have the information we need to make a decision.
The substitute motion is, and a second. The substitute motion is before us to pass it by for the day and see if we can't, you know, give Senator Hashmi a week to come up with what the status is of previous requests. Is that all right? Okay. All right. All right. All those in favor of passing it by just for the day, be on the schedule next week, so we can try to determine exactly what the status was of a study that was already mandated. All those in favor of that motion vote aye. Those opposed vote no.
No.
It's a recorded vote. I'm not getting, here we go. I got it.
Ayes 15, no 0.
All right. I think that concludes our calendar for today. Thank you all. Try to find it because